Your Lordship.
Yes.
I beg to mention item number 17, Lordship.
17.
Lordship, as per petitioner, respectfully do not want to press this petition.
You don't want to press?
Item number 17.
MSRD Learned Counsel for the petitioner submits that there are instructions not to press. One second, madam. কি এটা এটা? Sound তো। ঠিক করে লো বলে, কেউ ঠিক করো না। বন্ধ করো। কমাই দিও। Minimum amplitude. Also, that not to press this petition. Who is for the department?
Standing Council Elementary.
Elementary. Who is there? Anyone in the court? Bench to know more matters, no counsel from the department. Say kya?
Yes, sir. I can appear.
No. You don't need to appear.
They're on the way, maybe.
Court sits at 10:15. They should be here before the court.
It's a mention matter.
Doesn't
So,
matter.
we'll pass it.
No. We want to record their presence.
Lordship may record the name of SMPCC.
Somebody should be there. ये तो है।
Elementary কোন আপনার? In 1 minute we'll be here. He is already in the court.
We'll record his free SMT technical elementary education is present. The petition is according to this as not present. 17. Was there an interim order, madam? Yes. Item
56.
56.
There is a personal appearance. We have filed our affidavit in respect of respondent number 1 and 13. I'm saying a lot, but we need to bring on record.
Yes, please bring.
Regarding item number 28, Your Lordship.
28.
Yes, Your
Yes.
Lordship. It was fixed for the additional affidavit. We have prepared it, but the petitioner is unable to come and sign because of the flood, Your Lordship. He is in Barrett.
Item number
28, Your Lordship.
28. Matter of which year, madam?
2019, Your Lordship. Maybe 4 weeks time may be given, Your Lordship. So the situation and the communication has been severed, Your Lordship.
Okay. Your PDAS,
Yes, Your Lordship.
MSP das learned counsel. You have taken the counsel of the other side.
Higher education is on the other.
No, there are private respondents also. Be Purkasta. Madam, don't make a mention without informing. We don't like this kind of practice. You don't inform, you don't take consent and mention. Somebody will come when the matter is called up. Not this practice.
Lordship may be taken at 2 p.m.
We'll take it up, we'll adjourn it, but in their presence, after the information. We are not against the adjournment. We are on the procedure of adjournment. Yes, next.
I beg to mention item number
46.
Kindly
Yes.
adjust for a day, Your Lordship.
46 is connected matter with 45.
Yes, Your Lordship.
45 and 46 both.
46 only. Your Lordship.
No.
45 is
45 is which?
other have taken.
You cannot segregate one matter. You have to wait till the matter reaches. Okay. You're in, madam, you're in 45. They are seeking adjournment in 46. Is it RD is connected? Connected. Let the matter reach will be adjourned.
May it please your Lordship, for today's daily list 56,
we have filed our affidavit. for-
Bring it. Give a requisition. You for whom?
I'm on behalf of the
240. 41 is also there, madam. What about 41? 41 has got different concept. C. Chakraborty. Is he around?
We also given it
Okay, you inform the other side. Why are you seeking an adjournment? 19 matter, madam. We'll have it. When do you want?
after
We'll fix the date. 19 matter. Adjournment not for granted. Your name? S.
Patwari.
MSS Patwari, Learned Council, appearing on instructions of the UK Learned Council for the petitioners in this case, prays for an adjournment on personal grounds. Also, considering that these matters are of the year 2019, that these will be listed again immediately after vacation on 19th of July.
There is a
Interim order passed earlier shall continue to continue till the next date of listing. Yes. Keep present. Affidavit highlight.
May it please, my Lord, first of all, I should, my Lord, inform your Lordship. In the last few occasions, the petitioner came before your Lordship and his bail application was rejected. Now, the ground what we are agitating now, your Lordship will find your Lordship was never called upon. Lord, he made a statement before the police that he used to do the smuggle business of, my Lord, foreign cigarettes and Burmese bark. That is the allegation. The forwarding report also you will find. Lord, there is no material on record that these items come within the purview of narcotics.
That is not the allegation.
Well,
We are not dealing with foreign cigarettes and Burmese supari.
in the record you will find the material, psychotropic material was my Lord seized from Samsur Noor. The
We are
police
dealing
went
with some chemical drug for yaba
to-
tablet.
yes, you have a tablet.
Yes.
Now,
And what
that
is the quantity?
that is recovered.
2,59,000.
This is a commercial quantity.
Not commercial quantity. We are not on the commercial aspect.
Yes, much.
2,59,000.
Your Lordship is very correct. Now, it has been recovered from Samsun Noor. He hails from, my Lord, one village that is
See,
near
we have
Karimganj.
passed orders after considering every aspect. These are all organized crimes. We are not giving even a bit of indulgence to this kind of crime.
My Lord, I
We will not like to
I
change our
respect
opinion.
the decision, my Lord.
We will not like to change our opinion.
But I can persuade your Lordship if the record comes, I will show, my Lord,
Records are there, I think.
if it is there, my Lord, let me show that if there is any material, my Lord, I will not ask.
See, we are not on materials at this time. We are on prima facie satisfaction of involvement. We have recorded our observations. If you are aggrieved, you can very well appeal against it.
My Lord,
But we will not like to change our mind.
your Lordship, that is
2,29,000 are going to destroy the society
no.
and
Whether
that
it's
to chemical drugs.
the only thing your Lordship kindly see.
And see, we have refrained from making any other observation so that no prejudice is caused to you in the trial. We
Only
could have
thing,
made some observation. We have not made.
only thing your Lordship kindly see. It has been recovered from Samsun Noor. There is
Again,
no linkage has been-
it's not required that construct. You have to, the NDPS has to be in your position.
No, but then they
These
will
are all
have to-
organized crime.
they will have to establish that I have any link with this person.
That
So
will be
trial
established in the
meeting of-
trial. Prior fasa, we find that you are connected. We have seen the TD record.
My lord, I will just take your lordship to one page. My lord, in
No,
order
without
to-
if the records are not there, no point of arguing. You can call for the record. Did we call for the record? We had
No, my lord. Any new ground is there or not?
That's the new ground, my lord, what I am saying. That, my lord, from the forwarding report.
that
your
is not a
lordship
new
now-
ground.
No, no.
Forwarding report.
That
your
is not a
lordship.
new ground. New ground for
Those
bail.
Those were never placed before your lordship.
New ground for bail.
And if they can show from the records, my lord, there is material, my lord, I will not have.
Going into the city, my lord, it has been rejected.
We have not rejected once, twice, thrice it has been rejected.
My lord, my lord, third time what happened, my lord, it was withdrawn. And the other two times, my lord, your lordship said that the conditions set forth in section 37 has not been fulfilled. Under those two grounds, but then the materials, over the materials are there, the public prosecutor never shown there are some material. If there are materials, my lord, your lordship is right. Because it's a crime
No, these
against the society.
materials are only in the investigation stage. These may not be able to be proved in the trial. We are not saying anything more than that. We are on the prima facie satisfaction whether in the investigation anything has been found against you. And this being a very serious offense under the NDPS,
I agree. to
which
that.
is governed by
Yes,
37.
yes. Your lordship is very, my lord,
And
30
37 starts with a non-obstante clause, as
Yes.
you know.
I,
Whatever is there in any other law, this will prevail.
my lord, I am conscious of that situation. But again, 37,
Part-
my lord,
Free as Dr. Holland Senior Counsel for the petitioner who has
your lordship called for last chance, my lord, call for the report.
Who
Your
has
lordship can see any
filed
material.
this application under section 439 in so and so. The senior counsel has informed this court that on 3 earlier occasions, the application for bail of the petitioner has been rejected by this court. The learned counsel, however, submits that there are certain new grounds which may be considered. Let a scanned copy of the case record be called for. No, though this court is not too much inclined to entertain this petition, in the interest of justice, let a scanned copy of the case record be called for from the court of the learned special judge Karimganj in special NDPS case number 122 of 2021. Full stop. Registry to issue requisition for procuring the same. Full stop. List on. When do we have? We'll have it on 19th of July.
All.
19th of July. 3 is present.
Apply.
Ahile Heri. Okay. Who is that? Who is it? Yes, Mr. Chaudhary, what is this?
My lord, page 21 is the impugned resolution.
21. You have the record?
Record. The affidavit has been sent for vetting. So,
You have not filed the affidavit.
but it has been sent for vetting. If
Last occasion we had recorded your submission that you need time to produce the records, and due to some technical issue, it could not be obtained. How soon? What is the issue involved?
Issue, my lord, the
regarding prosecution of the
One-
SMD,
one, FMC was found, my lord, 5 years resolution, page 21, 14/9/21.
Page?
It is, my lord, violating the guidelines, my lord.
Page?
Page 21, the impugned resolution.
Is the SMDC constituted?
Yes, my lord.
Where is
It
the constituted?
my lord.
Where is the constituted?
My lord, that page 22.
22.
Yes, my lord.
No, this is the resolution.
This is the resolution.
Where is the
That-
constitution?
my lord, kindly see page 28, my
28.
28.
28 is a handwritten copy.
Yes, handwritten copy.
We are
That-
not at the stage of SMDC.
That is the
It needs to be, the order needs to be passed by the deputy commissioner.
but
Where is that order?
my lord, we have challenged that resolution, my
Has the resolution been acted upon?
acted upon, my
Where is the order?
that specific order is not passed, my
Then, without an order, can there be an SMDC?
but my lord, by way of that resolution, they are acting, they are running the instrument.
That may be done in an informal way, but there has to be an order by the deputy commissioner of the district. Without there being an order, how can you make how is this petition maintainable?
My lord, then my 2 days time may be granted. I will take this,
Mr. Chaudhary, you should know how to present a writ petition.
my lord.
This is pending since 2021. You have not taken any efforts to get a copy of the order of the deputy commissioner.
But the prime challenge in the repetition is that resolution. You have not
How a
challenged
resolution?
anything.
Resolution is a very premature thing. Whether it was acted upon or not, who knows? You withdraw this,
My lord,
will grant you liberty. Three, R3, H.R. Chaudhary, learned counsel for the petitioner. Petitioner, also heard. 3. B. Kaushik, learned standing counsel, Elementary Education Department, full stop. The petitioners have put to challenge our resolution dated, is it 14/9?
49,
14/9/2021 of by the in a meeting to constitute a school managing committee of the 72 number Borabari LP school in the district of Karimganj. Full stop. The learned council submits that such resolution is in contravention with the guidelines holding the field. Full stop. However, on a perusal of the petition, it is seen that no orders, no final orders for such constitution, which is to be passed by the deputy commissioner of the district, has been annexed and annexed or challenged. In that view of the matter, this court is of the view that the writ petition has been filed on a premature case. Para 3. Chaudhary, however, submits that he may be given liberty to make a formal challenge to the order passed by the deputy commissioner, Karimganj, if any, with regard to the constitution of the SMC of the school in question. Para. Writ petition accordingly stands dismissed with, however, with liberty as recorded above.
But in this case, only we have received the paragraph coming step.
How much time? 3 weeks time?
But the
Third K. Mazumdar learned counsel for the petitioners. Full stop. Para 3. B. Kaushik learned standing counsel, Elementary Education Department, however, submits that para-wise comments have been received recently, and he prays for some time to file the affidavit in opposition. Full stop. Para. List after 3 weeks to enable filing of such affidavit in opposition.
Earlier interim order may kindly continue.
Interim order passed earlier to continue to the next set of. What is 4? 4, Mr. Chaudhary, you are appearing.
connected.
Connected. 4 also there is an interim order. 4, 5. 5? File affidavit. Low, vote on. There is a contempt matter where a personal appearance is there, but the appearance, this affidavits are called for, which have not come. If you want, we can have it now, or we can wait for the affidavit to come.
In fact, Lordship, I am appearing for three of the respondents.
The
They have
item
filed the
number?
affidavit. Item number.
Why is this personal appearance?
Personal appearance because some of the containers, Lordship, alleged containers did not file their affidavit. That is the reason, but they are not in actually at the helm of affairs now. But still, they have all appeared today. And the,
Affidavit files or not?
yes, we have
All of you, all of
Yes.
them.
those who are not directed to be personally appeared, Lordship, they have already filed. So their personal appearance was not that.
Let us have a look at your earlier order.
15 order, Lordship. May come to the internal page. Paragraph 6 onward. Paragraph 6.
Yes, yes, yes. The ones who had appeared had already filed their affidavit earlier.
Yes, Lord.
My lord, for respondent number 8, I have filed.
Affidavit. Yes, can we know who are present?
Respondent number 4 is present.
No, let them come up.
Yes, Robinson Musahar.
What is your name?
Robinson.
You are R4. That's
R-
for number 4.
He is a R4.
You are presently holding what post?
No, he already retired from service on 31/1/2021.
As retired as
Retired as
Secretary
your
to
lordship.
Government
Yes. Ediman
And the
husbandry
retired
and
secretary to
veterinary.
Government of Assam.
Secretary to the Government of Assam. Which department?
Animal Husbandry and Urban Development.
Animal Husbandry and Veterinary.
Yes.
Okay. Who else, please?
Yes, respondent number 5, my lord. I am appearing, my lord. He was the additional principal secretary at the relevant point of time from, my lord, 2015 to 2016. Way back, my lord.
You are
For
Alok
passing-
Kumar.
Yes,
Respondent number 1.
Alok Kumar. You have retired
I retired in 2019
as?
I took the gate.
Okay.
Notice of contempt was issued by October 29th of amount.
Okay. Who else? Who else? You are implicated as respondent number 1.
Yeah.
Who else?
Filed an affidavit.
Representing the state.
Okay. Then next.
next, my lord, respondent number 5, my lord, Ravi Shankar Borgari. Now, he was the director of BTC, my lord, and he retired from service on 31/3/2020.
He was the director of
Education BTC. And the steps taken after receipt of the
retired on 2020.
31/3/2020, my lord.
Okay.
And within that time, my lord, this writ petition was disposed of 18/1/2019, my lord. All steps was taken, my
No,
lord.
no, we'll just record their presence. We'll
Yes, yes.
have the affidavit later on. Mr. Borgir, your response number?
5, my lord. 5. Respond number 6, my lord, Anupam Roy, my lord.
Mr. Borwa, you are for?
Respondent number 13.
Response number?
13.
13.
So we have also filed an affidavit.
You had retired when?
I retired on 31st August
R13. And your name?
Anupam Roy.
Anupam?
Roy. He is respondent number 6, my lord.
Retired as?
He retired principal secretary, my lord, and additional charge of commission secretary, WPT and BC. He retired on 29 February 2016, much prior to passing of the order, my lord, on 19/1/2019, 18/1/2019.
Who else?
My lord, I am appearing on behalf of respondent number 12, my lord.
Let
He
him-
was-
let him-
Siddharth Singh. Yes.
He has some
My lord.
difficulty. He has some
No,
difficulty.
he's there, my lord.
Then
He's
What is the
appearing.
meaning of a personal appearance?
No, no.
You don't want the court to interact with the party. If there is assistance, we will call you.
My lord, good morning. I am Siddharth Singh. I am presently serving as Commissioner Secretary in the Medical Education.
Siddharth
Research. Siddharth Singh.
Singh. Okay.
I am presently serving as Commissioner Secretary in Medical Education Research. I was
Your medical education.
and research.
This is an independent department.
It has been culled out of Health and Family Welfare. It looks after the medical.
Part of the health and family welfare department.
So it
Or it's
was-
a different department.
it's a different department.
Not a wing of the health and family.
No,
department.
New
Okay.
department.
You filed your affidavit.
Yes,
Your response number.
12.
Yes. Anyone?
For response number 15, my lord, we have filed Suranjana Senapati, Director of Elementary Education.
Where is she?
My lord, we have filed the affidavit.
No, that is not the question.
My lord, if does not file an affidavit. If does not file the
The
affidavit,
conditional order was
Did she appear earlier?
no, my lord.
Then where is gentleman appearing if they have filed the affidavit? You are somebody special. 2 o'clock. Ask her to appear. What is this kind of thing, Mr. Kaushik?
My lord, I understood
Only
wrongly.
you have understood the course order, they have not understood.
My lord, I understood or maybe wrongly, my lord.
This is how you understand.
Uh.
You are representing the department.
Uh.
All your colleagues have understood in a different manner. You are the only one who understood in a special manner.
Really sorry.
Not a question of sorry. It's your dignity, not our court's dignity.
Absolutely, my lord. I take
Dignity of the system.
I take
If
it.
there is an order from the court, you appear. Whether you dispense or not, that's a different matter. We are not on the justification of this order.
I'm sorry. It's my fault, my
At
lord.
2 o'clock.
At-
Who else?
Dr. I'm appearing for no, as good.
Yes?
Presently Commissioner and Secretary.
You are the
Commissioner and Secretary, Administrative Reforms and Training and Pension and Public Advantage Department.
administrative. Your response number
He's response number 14.
One-
1-4.
14.
In fact, he appeared. He filed his Okalatnama. He appeared also, but wrongly, Lord, it was shown as he did not appear in
Affidavit file.
affidavit, not yet filed. It is ready, Lord.
You file the affidavit.
Lord.
Anyone else?
My lord, I am appearing for number 8. We have filed affidavit yesterday. My lord, I was not, if my lord peruses the paragraph 8 of the order,
Who's responsible by
Dr. A. Angamat. My lord,
Yes.
his personal appearance was not sought for if affidavit is filed. There are 8, my lord.
you file the affidavit?
Yes, my lord. My lord, I have filed it yesterday.
Okay. Anybody else? Yes. You are R16. You are presently
there was no direction for his defense, but still he is present.
no. If there is no direction, you need not appear. There is no point bringing an officer to the court until there is some need. Mr. Chaudhary.
Yes.
The purpose is served.
Yes.
We are not on that person appearance. This is only because the affidavit was
No,
not.
my lord.
At the same time, we cannot also want to lack the court proceeding because of affidavit.
One
It has
person
come.
lordship order.
Yes.
Omar Jyoti Borman lordship, he has filed the affidavit also and he is present. Respondent number 11, for whom I am appearing.
R. Amarjyoti Borman.
Omar Jyoti Borman.
R.
R11.
Presently
Secretary, Board and Secretary.
BTC. You are still in service. File the affidavit.
No.
We'll dispense the personal appearance, but we are taking this matter at 2 o'clock.
Mile.
One officer has not appeared.
Mile.
We are not dispensing at 2 o'clock.
Mile.
I am appearing for respondent number 7 and 17, Lordship. Para number 11, it was stated that if we don't file our affidavit, then the personal appearance will be required, my lord. filed the affidavit for respondent number 17. My lord, the problem is respondent number 17 was impleted because respondent number 7 had left the office, my lord. And now, as I've been told,
You have filed the affidavit.
I filed the affidavit on behalf of the finance department. Both of them were the commissioner and secretary for the finance department. Lordship.
No, this is a contempt proceeding. It's not a question of finance department.
Yes, Lord. No,
We are against some certain particular individual.
Lordship, I'm just explaining that during the pendency, respondent number 7 retired, my lord, and respondent number 17 was impleted, my lord. So I filed the affidavit on behalf of respondent number 17, who has mentioned all the steps that has been taken by the finance department during the tenure.
7 is not required to file an affidavit.
Lordship, because that same instruction has been incorporated in the affidavit, my lord.
What steps did he take?
Lordship, they had sanctioned the amount, my lord. And
What steps did he take
Lordship,
during his tenure?
as,
Isn't he
mentioned
required
in
to
the
explain?
affidavit.
Isn't he required to explain?
Yes, Lordship, it's mentioned in the affidavit, my lord.
Filed by somebody else.
Lordship, because that was the in continuation, my lord.
If that is this matter, any new incumbent can cover all the other incumbents. That is not the purpose of a contempt. That you retire, you transfer, you are out.
Yes, Lordship.
He'll be out if you can show that during his tenure he had taken steps for compliance. That is
In the
the.
affidavit we mentioned during the whole entire time period.
We may not ask him to appear, but you file your affidavit.
Lordship,
7.
we are having difficulty contacting him because he's not in Assam. Respondent number 7.
Where is he?
Lordship, we have to find out whether we are having difficulty tracing him because he's not in Assam. Respondent number 17 is also not working in the department, but we
The
have
7 was a government servant, or is he retired?
he's transferred, Lordship. We don't know exactly.
You don't know where the government servant is.
Lordship,
That is your mechanism.
Lordship 17.
Him goes missing.
No, Lordship. Lordship may, in that case, but
See, there is an order of person appearance.
yes, Lordship.
You are taking it too casually. It seems.
No, Lordship,
All persons have filed affidavit.
Lordship, we have filed the affidavit on behalf of 17.
File for 7, we may not ask for his personal appearance.
Lordship,
What is the name?
Lordship Cham Jagannath. He is Lordship not even Assam. That is why we have.
He may not come to the.
He's in central. We'll find
Central
it.
He is not required to. We are not asking him. The
We'll
purpose
get
is
him.
not to cause any harassment to any person.
Yes, sir.
Purpose is to maintain the dignity. That is all.
Yes, Lordship. For 17, we have filed the affidavit.
File for 7 also. Part 3, K. Chaudhary Ranasine Council for the petitioner. Para. Also heard. 3, D. Saikya Ranasine Council. Give the names of all the council
4, 9, 11, and 16.
for respond number 9, 11. Please give in a sheet of
Yes,
paper.
it
We'll
will-
record. Then, pursuant to the order dated 15/5/2023, comma, the officers who were directed to appear, the following officers have appeared. Full stop. 3. Alok Kumar, who has been added as respond number 1, has submitted that he had retired in the year 2019 as the Chief Secretary and has filed the affidavit. 3. Robin Musahari has submitted that he has retired from the post of Secretary, Government of Assam, Animal Husbandry and Veterinary, that's number 4, and has also filed the affidavit. Similarly, 3. R.S. Borgieri, who had retired, number 5, who had retired as the Director of Education, BTC, in the year 2020, has also filed affidavit. 3. Siddharth Singh, the present Commissioner and Secretary, Medical Education and Research, added as respond number 12, has appeared and has filed the affidavit. 3. Jishnu Barua, respond number 13, who had retired as the Chief Secretary of the State in the year 2022, has appeared and submitted that affidavit has been filed. 3. Anupam Roy, respond number 6. Anupam Roy, respond number 6, who had retired in the year 2016 as the Principal Secretary, holding additional charge of WPT and BC has appeared and filed affidavit. Sri Shantanu Gotmare, respondent number 14, who is presently the Commissioner and Secretary, Administrative Reforms and Training, has appeared and filed the affidavit. Sri Anurag Goel, respondent number 16, who is presently the Principal Secretary, BTC, has appeared and filed the affidavit. Sri Amarjyoti Burman, respondent number 11, who is presently the Secretary, BTC, has also appeared and filed the affidavit. This court has been informed that who else has filed the affidavit whose presence is not required?
Number 8.
Respondent number 8 has filed the affidavit in whose case this court had made an observation in paragraph 8 of the order dated 15/5/2023 that in case the affidavit is filed, his personal appearance would not be necessary. Anyone else? Similarly, respondent number 17 has also filed an affidavit whose personal appearance was dispensed with in case such affidavit has been filed. Put up. Sri H. Alia, learned counsel, however, submits that so far as the respondent number 7 is concerned, he is presently not in the state of Assam and therefore could not be contacted. The aforesaid explanation is not acceptable. However, as a special circumstance, 2 weeks further time is granted to file granted to the respondent number 7 to file the affidavit explaining his conduct and his role. The order dated 18/1/2019. For the order which is the subject matter of this contempt petition. Three B. Kaushik, learned counsel, has submitted that respondent number 15 has not appeared as to her comprehension, personal appearance was dispensed with. The aforesaid comprehension being incorrect and also not at all justified, the state respondent number is directed to appear before this court personally tomorrow at 10:30. The personal appearance of the officers who are present today are dispensed with.
Number 14 is present.
Sri Madhupur Tripina, learned counsel. Shantanu Gotmare, affidavit. Sri P. Nayak, appearing on behalf of the state respondent number 14, however, submits that the affidavit, though ready, could not be filed today and will be filed tomorrow.
That case will be listed tomorrow. Lord.
Tomorrow, only for that purpose, then we'll speak it
Yes.
for consideration.
On marriage, Lordship is considering at 2 o'clock.
No,
Or
not
Not
tomorrow.
tomorrow.
Okay.
Tomorrow only for the purpose, then thereafter probably will be
Fine.
considered.
I'll
Okay.
point out, my lord, what is required.
Whatever is there,
Gabriel.
affidavit filed in the meantime may be brought on record.
Highly obtained.
Item number
Or supplementary 65. With this method, my lord, petitioner, they were selected in respect of a particular school. They belong to OBC category. And they did not secure 50% in OBC category. However, my lord, in the selection process, they were recommended by the selection committee being the most meritorious candidate.
The affidavit has been served upon you.
Yes, my lord, affidavit has been filed.
No. It was not served on the last day.
Yes, I have got,
We can take it up for disposal,
my lord.
Mr. Sharma. Yes.
WP taking up WP 3838 of 2009.
There are two writ petitions.
Yes, my lord. Both are issues common, my lord.
3838.
But if I take up WP 3838, the issue is similar in the other issues.
Okay. Okay.
But in both the cases, the petitioners they belong to OBC category.
How many petitioners are there here?
Two
In
petitioners in both the cases.
one petitioner
One
each.
petitioner in each.
3846. You belong to OBC category.
Yes, my lord. Both the
Okay, then
my lord, they qualified with the they appeared CAT, they qualified that examination. They did not secure 60% in CAT examination, as it is my lord. But my lord, for CAT lordship knows, my lord, the qualifying mark for general category is 60% in respect of both the papers, and in respect of OBC category and others, my lord, it is 55%.
you secured more than 55.
Why secured more than 55 in both the papers, my lord? That certificate lordship will find at page 22 of the restitution.
Yes.
Lordship will come to page 22, my lord.
22.
22.
Yes.
This is my lord Chitamuni Gogoi Das, the petitioner, my lord. Paper 1, out of 100, she got 61 marks. And in paper 2, out of 100, she got 58 marks.
This is who's this?
This is Chitamuni Gogoi, my lord.
This is the petitioner.
Petitioner, my lord.
Okay. This is the mark.
Mark.
Okay.
Just below that, my lord, the minimum qualifying mark,
Yes, we have seen 55 for OBC.
yes, 55 for OBC.
Hmm.
Thereafter, my lord, on 14th of lordship will turn to page 24.
What is the percentage here? It's more than 55.
More than 55, my lord. 55 is
61
the
and
cut-
58.
55 is the cutoff, my lord, for OBC.
Hmm.
And she got 61 and 58. Thereafter, lordship may kindly turn to page 24.
$56.5.
Lordship.
56.5. No, it's more.
Sorry, my lord. My lord. She got 59.5% in both and above 55 in both the papers.
And 59.5.
59
Average.
average. And 55 above in both the papers.
Yes.
My lord, lordship may kindly turn to page 24.
Hmm.
My lord, on 14 July 2016,
Hmm.
an office memorandum was issued by the state government, which laid down the procedure for selection of postgraduate teachers.
Yes, OM. This is
Lordship
what?
will kindly come
Guidelines
to-
for
Lordship,
guidelines
this is-
for recruitment.
Yes, my lord. Office member guidelines for recruitment to the post of postgraduate teacher in provincialized higher secondary school. Lordship may kindly turn to page 26.
Hmm.
This is clause 2. And 3, my lord.
26.
Page 26. My lord.
Yes, clause 2. Important.
Important
Eligibility.
eligibility criteria. Candidates who qualified in tests conducted for postgraduate teachers are only eligible to appear for the post of postgraduate teacher. Clause 3. The minimum educational and professional qualifications shall be required for the post of postgraduate teacher as below. MA, MSc, MCom with 50%, and so and so, my lord. So basically, my lord, if they have to get qualified and others, my lord, as per provided.
Yes.
Therefore, after on page 33,
Hmm.
an advertisement was issued.
33 years.
31st notice, my lord.
Hmm.
Notice come to serial number 5.
And what is the date of this advertisement?
It's 28th of February 2018. Down below, my lord.
Yes.
Lordship, come to serial number 5. Soikwa HS School.
Hmm.
My lord, the petitioner applied for the post of education which was for open category. Postgraduate teacher education.
Hmm.
Lordship, got it. Now, Lordship, kindly turn to page 41. Page 40 in fact, my lord.
Hmm.
This is the comparative statement of marks obtained by the candidate, where, my lord, the petitioner
Page?
named page 40, my lord.
40.
Annexure I. 40.
Yes.
Lordship will see, my lord, at serial number 1, Hitamoni Gogoi Das, that is the petitioner. This
Serial
secured
number
to-
3.
My lord.
41.
Page 40, my lord.
40. Yes. 40 at serial 1 petition.
Serial 1 is the petitioner. She secured 273.44 marks. And the other two, my lord, second candidate, he got 269.1. And the third candidate, he got 265.33.
Hmm.
And Lordship turns to the next page, my lord. The breakup of marks is also provided at post 41.
Hmm. Yes.
My lord, being the most meritorious candidate, petitioner was recommended for the post of postgraduate teacher.
41 has got a breakup of marks.
Yes, my lord.
Hmm.
My lord, the name of the petitioner was recommended by the selection committee.
Where is it?
My
where
lord,
is
that statement I have made, my lord.
Petitioner recommended.
Yes, my lord.
Okay.
But he was not recommended for. He was although recommended by the
Not appointed.
not appointed, my lord. And Lordship may turn to page 42. But the petitioner filed a RTI application whether any appointment has been made.
Yes.
To that effect, my lord, page 42 may kindly be present.
Hmm.
With reference to the subject cited above, I am directed to furnish here
Where is,
with
where is your school?
his Soikwa Higher Secondary School.
Where? Where? In this,
Page 42, my lord.
in 43?
Not-
Where is that school?
It's in Tinsukia, my lord.
No. Where is the name of the school here?
Now, Lordship, may kindly turn to page 42.
42 we have seen here. 42 is the,
That no appointment has been made yet, my lord.
oh, no appointment.
No appointment.
Okay.
Page
We thought the appointment were already made.
Although my name is recommended, my lord.
No appointment made in your school.
Yes, sir. And the reason for not recommending the name has been stated in the affidavit, as well as verbally informed that the petitioner did not secure 60% marks. Although the post was for open category, he also have secured 60% marks, and that is the reason.
Where is the affidavit? Where in the
Lordship, it's the affidavit paragraph, my lord. It is stated 4 and 5, my lord. Mainly paragraph 5.
19 June 2023. 4 and 5, yes.
Here it may.
Mhm.
That the deponent stated the pursuant to advertisement dated 28/2018, the petitioner was appeared in the interview which was held on 10/3/2018 for the post of postgraduate teacher of education open in Soikwa ITS School district in India. As per provisions of Assam Secondary Education Provincialized Service Rule 2003 as amended in 2012. According to Rule 10 of the Assam Secondary Education Provincialized Service Rule as amended in 2012, states that the academic and professional qualification for direct recruitment shall be as in Schedule 2, provided that in addition to such academic and professional qualification, method mentioned in Schedule 2.
Okay, we have read this.
And paragraph 5, my
We
lord.
have read this. Okay.
So that is the reason. In fact, my lord, Rule 10 has been, my lord, misquoted in the affidavit. Lordship may kindly turn to Rule 10 of the Assam Higher Secondary Education Provincialized Circular 2003.
Page
Lordship, if Lordship is holding
Same
the
book.
same book, my lord, it will be page 375.
375. Yes, please.
Rule 10, my lord.
Yes.
Academic and professional qualifications.
Hmm.
The academic and professional qualifications for direct recruitment shall be as in Schedule 2. Lordship may come to second proviso, my lord.
Hmm.
That has been misinterpreted totally, my lord. Provided further that the conduct of that eligibility test, teacher's eligibility test, shall be an eligibility test and not test for recruitment for the post of teacher. Qualifying in that the teacher eligibility test shall not entitle any person to claim appointment as a teacher. So, part of the case of the petitioner is that the C qualified by securing 55% mark.
Yes, yes, Mr. Sharma.
But my argument also
We'll consider that.
My lord, provision 10 of the Assam Secondary Education Provincialization Service Rule 2003 clearly states that for general category of candidates, 60% marks is required, and for ST, and OBC for 55% marks is required. And she appeared in the interview on open category. Open category means general category. So
Hey,
general
Mr.
category-
Sharma, there are two separate compartments altogether. One is eligibility.
Yes.
One is being selected. You have to be eligible to come within the zone of consideration. What is the requirement for an OBC candidate? That to be eligible, you need to secure more than 55% mark in the TET examination. You become eligible. You come to the zone of consideration.
Yes.
Once you come to the zone of consideration, an OBC, as you know, a reserved category candidate can also apply for a general category and be appointed in those posts which are meant for unreserved, if he or she can secure a better mark in the selection test. Now there is no hard and fast rule or barrier for a reserved category candidate to apply for an unreserved, which may not be the reverse. An unreserved cannot apply for a reserved category. She had applied. In application, the objection which you are raising would only be at the time of application, not at the time of selection. And the provisor is there. Even in a case where such provisor is not required, it's a subtle law that these are two different aspects. One is eligibility, one is selection. I don't think you can, that objection of yours would be a valid objection. These are matters which are settled in service jurisprudence. In an open competition, if a reserved category candidate mark which is more than an unreserved category, then he will be in fact treated as an unreserved category. That reserved vacancy will still be there. What
Yeah.
about the other case
Other case
the
is
other case
similar.
where school is different, like that of same, my lord.
against first position?
Must still turn out first position, my lord.
A different
School
school.
is Jalukuti Higher Secondary School. It is-
Same advertisement.
My lord, the advertisement, my lord.
What is the case you are trying to refer to, Mr. Chakraborty?
My lord,
What is the case law?
lordship.
Which one?
Lordship, it is, my lord, 2017 1SCC 350.
Name.
Name, my lord, Visakha Sankalya,
Vikas Kankal.
Vikas Sankalya versus Vikas Kumar Agarwal. Lordship, I have,
No, there are other cases also.
well, issue is there, my lord. Lordship, I have black mark, my lord. Exactly the issue which was framed in this court, my lord.
No, there are other, many other. You say that, you tell the name applicant.
The issue number 3, lordship. That's like not the issue.
Whether reserved category.
Well, yes, sir. Whether reserved category candidates who secured better than general category candidates in recruitment examination can be denied migration to general seat on the
Where is the
basis that
answer?
they had availed relaxation in that.
Where is the answer?
My lordship, at paragraph 60, my lord,
60.
60, my lord, page number 29.
Please read.
Having regard to the respective submissions noted above, the first aspect that needs to be that needs consideration is as to whether relaxation in that pass mark would amount to concession in the recruitment process. The High Court has held to be so on the premise that para 9A dealing with the relaxation in that mark form part of the document which relates to the recruitment process. It is difficult to accept this rationale or analogy. Passing of TET examination is a condition of eligibility for appointment as a teacher. It is a necessary qualification without which a candidate is not eligible to consider for appointment. This was clearly mentioned in the guidelines notification dated so and so. But in this case also, my lord, there was a guideline which provided that TET is only a qualifying mark. These guidelines pertain to conducting of TET, basic feature whereof have already been pointed out above. Even para 9, which provides for concessions that can be given to certain reserved categories, deal with qualifying marks that is to be obtained in TET examination. Thus, a person who possesses TET examination becomes eligible to participate in the selection process as and when the selection process or for filling up post of primary teachers is to be undertaken by state. On the other hand, when it comes to recruitment of teachers, the method for appointment of teachers is altogether different. Here, merit list of successful candidates is to be prepared on the basis of marks obtained under different heads. One of the heads is TET. So basically, my lord, in this case, I have shown the breakup of marks. It is not a case that petitioner was given any added advantage for in the TET column, my lord. Whatever marks he got in the TET examination, that was counted, and thereafter, on the basis of that, her name was recommended, my lord, being the most meritorious candidate. Therefore, my lord, in my respectful submission, the other requisition, my lord, the school is different, my lord.
Yes, what is there? This is 3842.
Lordship, 3842. The school is Zaluguti Higher Secondary School in the district of Morigaon. And the post is
Zaluguti.
Zaluguti. And it is the post of education, my lord, postgraduate teacher for education.
Zaluguti.
Higher Secondary School.
Advertisement dated.
Yes, my lord, here also petitioner in paper 1 both 55.
Advertisement dated.
Advertisement, my lord.
23rd of February
23rd of February.
2018. One post.
23rd February 2018.
And you applied for open category.
Open category.
In which PGT?
My lord, post education, my lord.
Education unreserved.
Your category. Secured how many marks? First.
First, my lord.
What was your TET result?
My lord, that is the lordship at page 21, my lord. Paper 1, the petitioner secured 55. In paper 2, he secured 59. The percentage is 57, my lord, and above 55 in both the papers.
That consists of two papers. That consists of two papers.
Two papers.
And you also see, obtain RTI information here.
My lord, I obtained RTI, my lord, that
You have filed affidavit.
yes, my lord, the page 45 may be seen, my lord.
Affidavit filed.
Affidavit file,
Similar.
same 10 has been taken. And my lord, page 45, my RTI reply, my lord, reason has been provided also that I have not secured 60% in the TET examination, that's why it has not been.
And no appointments made.
No appointment. But they have also filed affidavit, but they have not stated anything. And RTI reply also results, my lord, that's post.
Post is still lying vacant.
Like at the time of I think receipt of the RTI. Like,
Anything more, Mr. Sharma?
My lord, regarding the vacancy of post, I have to take instruction whether it is lying vacant or not. Till that.
If you have made appointments by private respondents made parties, oh,
My
there,
lord, no,
there
there
are
was
no
no
appointments.
appointment, my
There
lord.
are no appointments.
Otherwise, also, my lord, while issuing notices, my lord, it was specifically provided that any appointment will be subject to outcome of the report.
While issuing notice.
Yes, while issuing.
Hello, order, no? Heard Priti Chakraborty, learned counsel for the petition. Also heard Sri U. Sharma, learned standing counsel, comma, secondary education department, appearing for the respondent. Principal, anybody has appeared? You are appearing for the principal.
No, no. The principal, my lord, in respect of other case, affidavit has been filed, my lord. And they stated that the second case, my lord, no appointment has been. That is their fault. And they have forwarded the name to the committee. And
But nobody, none has appeared for the airline. Please have your seat. The issue is with regard to the selection and appointment as postgraduate teacher of the petitioner, wherein the question of her eligibility vis-a-vis the TET qualification has arisen. Full stop, para. The petitioner, the projected case of the petitioner is that he or she, both, she is a postgraduate degree holder in education and belongs to the OBC category. Full stop. The petitioner also claims to have qualified the teacher's eligibility test within the TET examination for higher secondary, securing 59.5%. The Learned Council has also drawn the attention of the court to the mark sheet of the petitioner regarding the TET examination, wherein the individual marks of the two subjects of the two papers, papers are more than 55%. The petitioner claims to have possess all the qualifications for appointment to the post of postgraduate teacher as per the Assam Secondary Education within bracket provincialization service rule, 2003. Full stop. Para. An advertisement was published on 28/2/2018. ये हो जाएगा दूसरा केस 23/2 अलग for filling up of postgraduate teacher in the Saikwa Higher Secondary School in the district of Tinsukia. ये हो जाएगा जालूगुट्टी Higher Secondary School in the district of Muri. दूसरा as per the said advertisement, comma, the post of postgraduate teacher in education was an unreserved post. Full stop. Para. It is the case of the petitioner that she had applied for the state post and had participated in the selection process. Full stop. The Senate Council selection process has also drawn the attention of this court to an OM dated 14/7/2016, which provides for the recruitment to the post of postgraduate teacher in provincialized higher secondary school. Under the eligibility criteria of given in the state OM, comma, it has been laid down that candidates who had qualified in the TET conducted for postgraduate teachers are only eligible to apply for such post. The minimum qualification has also been prescribed as minimum qualification. The petitioner submits, it is a case of the petitioner that she has also secured the minimum educational and professional qualification as per the state OM. In the selection so held, comma, the petitioner had come out successful and was adjudged as the candidate with the first position, securing 273.44 marks. Full stop. It is the case of the petitioner that upon such completion of the selection process, comma, though her name was recommended, comma, the offer of appointment was not given to her. Full stop. The learned counsel, Sri Chakraborty, submits that from information received as well as from the stand of the respondents, discernible from the affidavit in opposition dated 19/6/2023, comma, the reason for not offering the appointment to the petitioner is that she had not obtained 60% in her TET examination. Full stop. Correct. The learned counsel for the petitioner has referred to the rules of 2003. ऊपर जो एक बार लिखा था, Hearing Rule 2003. More specifically, Rule 10 thereof concerning academic and professional qualification. Full stop. He submits that the second proviso to the state rule makes it clear that the qualification in the TET is an eligibility and not a test for recruitment for the post of teacher. Full stop. It has further been clarified that qualifying in TET shall not entitle any person to claim appointment as a teacher. Full stop. The Senate Council has accordingly submitted that deprivation of the petitioner from the appointment on the ground that she had not secured the benchmark, in the TET examination, which is meant for an unreserved candidate, in spite of the fact that the petitioner belongs to the OBC category, comma, the aforesaid action is wholly unreasonable, misconceived, and therefore is liable to be interfered with. Full stop. By drawing the attention of this court to information received under the RTI, comma, the learned counsel has submitted that the vacancy still exists.
It was RTI established by 14th of May 2000.
The vacancy still exists. Full stop. Para, in support of his submission, comma, Sri Chakraborty has relied upon a decision of the Honorable Supreme Court in the case of Vikas Sankhala versus Surensu, reported in 2017, 1 STC 350. Full stop. Para. On the other hand, comma, Sri U. Sharma, learned training counsel of the department, has defended the action of the respondent by submitting that if the petitioner wants to compete in a vacancy and for unreserved candidates, comma, the eligibility for such unreserved candidate eligibility conditions meant for unreserved category candidates would apply. He submits that the benchmark for unreserved category is 60% in the TET examination, whereas admittedly the petitioner has secured marks less than 60% in the TET examination, and therefore she was not eligible for consideration for such appointment. The rival contention made by the learned counsel for the parties have been duly considered, and the materials before this court have been carefully examined. Full stop. The reason which has which is forthcoming from the affidavit filed by the respondent as well as by the stand taken by the Joint Standing Council of the department is that the petitioner did not secure the benchmark meant for an unreserved candidate in the TET examination as in the TET examination. Such stand has been taken in view of the fact that the petitioner, who though belongs to the OBC category, had offered her candidature against the vacancy in the unreserved category. Full stop. The aforesaid contention is a fallacious one, inasmuch as there is a clear distinction between a candidate being eligible and a candidate being ultimately selected for a particular post. Full stop. The eligibility, the fear of considering eligibility cannot come into the way in the issue of offering of appointment, in the issue of the selection once the candidate has been held eligible. Full stop. Para. It is, though it is true that the benchmark for OBC candidate and unreserved candidate so far as being eligible in respect of the TET qualification is concerned, once such eligibility criteria is met by a reserved category candidate, there is no bar for such reserved category candidate to compete in a post held, in a post vacant for unreserved category candidate. Once the selection is conducted, the same has to be finalized on the basis of the performance and the marks secured in such selection, and at that stage, the authorities cannot revert back to the issue of eligibility, which had otherwise attained finality. This court is also of the opinion that if eligibility was at all an issue, the petitioner should not have been allowed to participate in the selection process, which was not done. In any case, the petitioner, and in any case, the petitioner's eligibility not being questioned, which also appears to be in consonance with the law governing the field, the same cannot be brought in at the stage of offering the appointment on the basis of the performance in which the petitioner was evaluated to be the first nominee. This court finds forth in the contention made by the learned counsel for the petitioner, and has also found that in the case relied upon of Vikas Kankhala Supra, the issue has been adequately explained. The relevant part of the judgment is extracted herein below for a better understanding of the position full stop. Page 14, issues to be decided लिखिए, dot 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 27 dot 27 लिखकर dot 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 number 3 लिखिए, whether पूरा लिखना है, okay, to effect whether there. Then you come to paragraph 60. पूरा quote कर, it is seen, this court has seen that the Honorable Supreme Court had taken into consideration the leading cases on the field before coming to the aforesaid conclusion. This court, in view of the aforesaid factor, this court has also been apprised that the posts in question are lying vacant. Those three U Sharma, the London Standing Council submit that he does not have the instructions as to whether the posts are vacant as on today, this court has noted that while issuing notice, an observation was made that any appointment made could be subject to the outcome of the petition. Under those facts and circumstances, this court is of the firm opinion that while allowing the writ petition, a direction be issued to appoint the petitioner by virtue on the strength of her selection made pursuant to the advertisement in question. Therefore, the appointment be offered within a period of 45 days from the date of receipt of a certified copy of the writ petition is allowed. दोनों में एक ही होगा, बस वो चेंज होगा और उसमें होगा
In respect of the second method,
second I'm just second जो है she has secured more than 55 wickets or average is 57%.
with respect to the second method,
Hmm.
I have not annexed the mark method, but it is apparent from the RTI reply itself that the petitioner took second method, took first position. The marks were not annexed with respect to the second method.
It's taken for the first में जो है has not yet in silver market, इसमें अलग लगे so the market as we teach Chakraborty learns counsel for the petition submit that in spite of best efforts, the market could not be obtained. So, however, from the reply in the RTI application, it is discernible that the petitioner had obtained the first position
In the
in the selection.
deeply obliged.
May I please? I is for implement of party. Notice is to it too. And subsequent there to a planted liberty to take the tracking report from the register. To take effect by the
Just
additional
a minute. Ten-4 notices were issued.
My lord.
And you have given the track report.
Yes, my lord. That my lord will find in the additional affidavit black D.
Like D.
Page 46, my lord. These were given to my lord, and at page 47, my lord, delivery report, and page 40.
47, which one?
Page 47 for Vijoya, my lord.
Which one?
Respondent number 2.
Understood. There are many articles here. Which one?
Page 46, my lord, the first one relates to Sanjay Suranjan.
Okay.
Second one relates to Vijay.
These are what tax reports.
My lord, that is, this has been furnished to me by the registry. Notices were issued to
1231.
that 1231, my lord, is cited page 48 on the left hand. And 1280, my lord, is cited page 45.
7.
1280.
Who's for the department? Education. This is what elementary.
Elementary.
Elementary. Mr. Sharma, see, this is a content matter. You are not necessarily required to appear. But Mr. Kaushik, this is a content matter. You are not necessarily required to appear unless you have the instructions. But it appears that the track report is also there.
Hello.
2 of the respondents have been served.
Hello.
We don't want them to face an embarrassing situation.
I'll take note of it.
You take note,
Yes.
inform them, and you know what advice to
My
be
lord,
given.
I'll
Because if we hold that they are not appearing in spite of notice,
Alright.
we'll call for a person appear.
I'll take care of it. Doctor will give me an
No, we'll not say anything. We'll not say anything.
My lord,
You are asking you informally
my
to
lord.
take note of it. Third to H.K. Sharma, learned counsel for the petitioner, who submits that no notices were issued in this application for implement of new incumbents.
Notices were issued 10/4/2000.
Notices have been issued.
Yes, ma'am.
We have said
Oh,
no notices were issued to the incumbents who are presently holding the post, and steps were taken, comma, they have not appeared. Full stop. The learned counsel has also drawn the attention of this court to an additional affidavit by which the postal track report has been annexed, which has been done pursuant to an order dated 15/5/2023, passed by this court in this proceeding. Full stop. Full stop. The said affidavit has been produced, including the postal track, as per which the notices were served on the incumbent. Full stop. Para. However, the incumbents, since the incumbents are yet to appear, comma, in the interest of justice, further period of 2 weeks is granted to enable the incumbents to appear, in default of which, comma, this court would be constrained to pass appropriate orders.
Think a date.
List on 19th of July.
much of
Mr. Kaushik, who are the two incumbents you can take?
I have taken.
Wait, Mr. Lordship.
Yes,
Mr. Lordship, there is a treatment application in this petition. Lordship, I need some more time, 1 week time to file objection. Otherwise, I would have not.
yours is for the petitioner.
I am for
Somebody wants to implead. Who wants to implead?
I am for the applicant, Lordship, in the
In the writ petition.
in the
What is the writ petition about?
This petition was against the because we were selected initially as the founder lecturer in the Polytechnic College, and showing our name only, they got the approval from AIC, and subsequently there was immediately we were recruited not by the APSC but through a valid selection process by the department. That is the so we have though irregular, but we have certain rights. So then there was an advertisement for regular selection. We applied for that. However, there was no notification for the written examination for around 3 to 4 years. So in between, after when it was the notified.
Now, why are you objecting to their implement?
Your Lordship, because otherwise I would have not, usually I don't object to implement. Here they have, because they are not even applicant to their advertisement, Your Lordship. And they are only.
We'll decide that.
They are not in pursuant to
No,
their
if we give somebody a hearing who has come before the court, what objections can you have?
right, Your Lordship, but
If we think that they are wholly irrelevant or their submissions are not having any material effect in your case, we will not accept their submission. We'll allow this.
Lordship,
IA for implement, that too in a
I
writ
vote on.
petition. You for the,
You wish.
no, you for whom? How many applicants?
16 applicants are here, Lordship.
To be implemented as a floor number?
17 to 32.
And Mr. Bothakur,
Lordship, I am in item number 9.
you are also filing an
No,
implement.
no, I have already been implemented. My case is different.
Mr. Sharma is the advocate in the other case also.
yes,
He is appearing in the other.
only in the 7.
Who's in the other case? Madam Chutia, you are appearing. Bothakur has been implemented in your matter.
In item number 9. 6005 of 2000.
And how many? There are 3 more items.
I am in.
Huya is for the department, higher education. And madam? APSC. And what about the other 3 matters? Who are appearing? Sharma is for
For 7 years.
item number 7, WPC 8795.
Yes, Your
correct?
Lordship. Matrimony board.
PN Goswami, K. Pathak, S. Chutia, you are there. You are for 8 and 9. And 10 is an IA by APSC. Madam, what do you need, Mahanta? What do you need in the IA? No, your IA has been filed 3095, obviously with some prayer. What is your prayer? That has been disposed of.
No, that has not been.
Have you done so? You have done it. Okay, we will consider on another day. Today we'll allow Mr. Sharma.
Otherwise, Your Lordship, the whole process of selection got stalled due to the interim order passed. Your Lordship, in
Oh,
item
19
number 9.
matter.
No.
Item number 9, Your Lordship.
No,
19 matter.
Lord.
We'll
Item
have it
number 9.
immediately. We'll have it.
Immediately after.
Let them file the affidavit.
Lord.
We allow Mr. Sharma to be included.
Lord.
Otherwise, affidavit haven't filed. You have filed
Lord,
affidavit.
Lord.
3. UB Sharma,
Yes, Lordship.
Senate Counsel, for the applicants who by means of this application has paid for implement of the applicants as party respondents. On the last occasion, when this matter was listed, that is on 29/5/2023, time was granted to the learned counsel for the opposite party writ petitioner to file objection, which however has not been done till today. This court, after hearing the parties, is of the opinion that allowing this implement will not cause any prejudice at this stage to the petitioner, to the opposite party petitioner, and the inter se marriage would be considered and adjudicated only at the time of the final hearing. In view of the above, the present IA stands allowed, and the applicants are implemented. Applicants who are how many number? 9 in numbers.
16 number.
16 in numbers are implemented as response numbers
17 to 32.
17 to 32.
Yes.
Have you checked? 7232. After you have come in, what is your number?
My number, my writ petition is.
No, what are your numbers in the
He
writ
is in
petition?
another
Not in
repetition.
this,
Not
Oh,
you.
in the other, 7232.
I have already been.
I accordingly stands allowed. In the main writ petition you write, in WPC 8795/2019. In view of the order passed today, that is to ensure, whereby the implement of new incumbents have been allowed, registry to insert the name of the new incumbent as respondent numbers 17 to 32.
17 to 30.
17 to 32 in this writ petition. Full stop. Consequently, Sri U.B. Sharma, learned counsel for the newly imputed respondent number 17 to 32 is granted 2 weeks time to file the affidavit in opposition. Whereafter, the petitioner will be at liberty to file rejoinder affidavit.
May I pray for a date, your lordship, in respect of the main matter?
This we have some 2 weeks after the vacation immediately. Para- Since since this court has been apprised that there is an interim order with regard to certain selection and appointment in these writ petitions pending pending since 2019, let these matters be listed on 21st of July, prior to which the pleadings are required to be exchanged.
Hello.
Obliged.
Yes. Yes, madam, what is this?
Please, your lordship. Lordship, this matter might have become infructuous. However, lordship, we do not have the exact instructions. So, lordship, may kindly grant us some more time.
We'll close it, we'll grant liberty to the petition. If there is any
Lordship,
live,
just one date, lordship, so that we can have the exact instructions.
no, we'll give a liberty. If there is any live cause of action, they can revive. Okay.
Otherwise, also, this speaking order by which their claim has been rejected, that was filed by way of an affidavit we brought on record in 2017. Consequently, this order has to be followed if they are agreed by this speaking order.
Okay.
Because at that point of time, their petition was
Madam,
giving a direct-
we forgot your name.
N. Begum.
M. Begum.
N.
N. MS N. Begum, learned counsel for the petitioner submit that though the matter, though this writ petition does not appear to have an existing cause of action, it does not have concrete instructions from the client. Full stop. On the other hand, Sri B. Kaushik, learned pending counsel, Secondary Education Department, submit that a speaking order was passed, which is also brought on record by way of an affidavit, which, however, has not been put to challenge. In view of the above, this court is of the opinion that there is no live cause of action in this writ petition unless the aforesaid order dated
the speaking order is 25th of July 2016. 2507.
25 July 2016 is put to challenge. The writ petition accordingly stands dismissed as infructuous. However, if there is any live cause of action, liberty is granted to the petition to approve this court for revival.
Much
Revival.
Obliged.
Yes, my lord. Petition number 1, 2, 3, and 6, my lord, only province is there.
They have
Province side, they got province side. And 5 and 6, my lord, 4 and 5, my lord, under process.
you withdraw this then.
My lord.
Heard Sri A.K. Azad, learned counsel for the petitioners. Also heard MS R.B. Bora, learned standing counsel BTC, as well as Sri S. Das, learned standing counsel Higher Education Department. Sri Ajad, the learned counsel for the petitioners, submit that during the pendency of this writ petition, comma, 3 of the writ petitioners have already got the benefit of provincialization of their services, and for the remaining 2, comma, the same is in process. Put the para. He accordingly submits that there is substantial compliance, that the grievances of the petitioner have been substantially redressed. Put the para. In view of the above, the petition is closed.
Four petitioner already presented.
4, not 3, 4.
Not
Four.
six.
4 of the petition and for 1 is in the process.
If the
May I please,
Well-
Lord, may I please, Lordship?
Yes.
Lordship, kindly attend the matter for a day, Lordship. I am appearing on behalf of Kalyani Devi.
She is not well over.
No, no, Lordship, her brother-in-law early in the morning expired. Today.
Right? Okay. This court has been informed that there is some bereavement in the family of MSK Devi, Learned Council. That this matter be listed immediately after the vacation.
Deeply
Obliged.
obliged, Lordship.
May I please, Your Lordship? Lordship, last occasion, Lordship, I could not reply. I apologize for that, Lordship.
Doesn't matter. What is it now?
Lordship, here in this case, the petitioners was accommodated and they are
As tutors,
tutor.
you are withdrawing this.
Actually, it is not withdrawn because since 2007, Lordship, I have done getting any my salary. My salary has not been released since 2000 August 7.
It depends on you. If you want to pursue, we can have this, or if you think that you have got substantial relief, it's up to you.
The petitioner number will be
How many petitioners are there?
you will attain the age
How
of
many petitioners are there?
only 2 petitioners.
You think over, I think you should withdraw, so you have got something.
Lordship, I will withdraw.
What is your name?
Mr. K.K. Henry, Lordship.
K.K. Hendrik. Three K.K. Hendrik Learned Council for the petitioners. Submit. No, don't write like that. When this matter was listed on the last occasion, that is 16/6/2023, comma, though the Learned Council for the petitioner was not present, comma, this court was informed on behalf of the department that the petitioners have been accommodated as tutors and therefore they may not have any existing cause of action. 3. K.K. Hendrik, Learned Counsel for the petitioners has appeared today and has submitted that it is a matter of fact that the 2 petitioners have been accommodated as tutors. However, comma, the salary issue has not been resolved as yet. Para. The Learned Council, however, submits that since the petitioner, what about the other petitioner?
He is also been accommodated.
No, retirement.
He will retire at 2023, 2027.
Since one of the petitioners is at the verge of retirement, and the petitioners are now accommodated as tutors, comma, they would not like to pursue this petition any further. Also heard P.K. Bora, Training Council, Elementary Education Department, and Sri B. Gogoi, Training Council, Finance Department. Petition accordingly stands closed.
Deeply
Welcome.
Lordship, I have a prayer with regard to item number 56. Lordship, my name may be recorded against respondent number 18. Lordship.
Appeared or not?
I mean the item, Lordship.
No. Who was the respondent? There was a personal appearance.
Lordship.
Has your client, did your
No,
client
no,
appear?
my officials were not directed, Lordship.
You have filed affidavit.
Lordship.
Number?
18 lot.
R18.
Respondent number 8.
এক্ষুনি লিখে MDB for
On behalf of Mr. Ada.
MDB for respondent number 18 who has filed. Okay, 5 minutes.
Giving of salary of assistant.
Yes, Mr. Bora.
Well, we have not received any instruction yet.
Why?
Probably
17 matters.
she has accommodated in this case. Madam.
He has been accommodated.
Probably, madam. I'm not sure, madam.
Yes, any instructions, madam?
I have not received.
This matter, notice of motion was issued in 17. Thereafter, it has not come up for proper consideration. You get the instruction.
Madam, I'll take.
You also get the instructions whether there is any life for the victim.
After
It appears that
Lordship, item number 15 and 16 is also similar, not getting the salary.
and
Here the date is different.
when were notices issued, madam?
Same 2017, Lordship.
17.
But in item number 15, salary is not getting from the date of her initial effort.
And 16,
16 is from October 2003. 14 is August 2000.
4 17. 17. प्राप्त रही थी Third, MSD Angana Learned Council Common Authority for the petitioner in these cases. Also heard, Madam, Mr. Bora,
Madam.
what about the other two cases? Any instructions, concrete instructions?
In Dipamoni Bora Dotto not approved by the government for accommodation. In item number 15, my lord, not approved by the government for accommodation.
Okay, yeah, the one.
In item number,
Naveen Gohai,
we have not received any instruction.
also heard, 3 Bora, 3K Bora Learned Training Council, Elementary Education Department. These matters pertain to the grievance of non-receipt of salaries. Para. It appears that after issuance of notice in this case by this court in the year 2017, the same has not come up, have not come up for proper consideration, and instructions are also awaited, and instructions have also not been received, and complete instructions have also not been received by the Learned Training Council for the Department of Para. The Bora, however, submits that so far as the petitioner Monimala Hazarika in WPC 2031 2017 is concerned, she is accommodated as a tutor.
No, ma'am. Item number 16, Dipamoni Bora Dotto, no, not approved by the government for accommodation.
Others you don't have instructions.
My lord, in other matters I don't.
Okay.
15,
Complete.
15, only 15.
The Bora, however, submits that so far as petitioner Dipamoni Bora Dotto is concerned in WPC 2208-2017, the government has not given approval for her accommodation as tutor, correct?
My lord.
Let these matters be listed immediately after the vacation to enable the Learned Council for the parties to obtain appropriate instruction.
Obliged.
Lordship, may it please, this is the matter relating to non-payment of salary belonging to Sibsagar district, Your Lordship. They provided me with a copy of their communication, dated 13 January 2022, wherein they have stated that we have been accommodated. I like to take instruction from my client, Your Lordship.
Okay.
The last week of July, Your Lordship.
MS Chief Learned Training Council submits that to this petition was filed pertaining to the issue of non-payment of salaries, he has been informed with an order regarding accommodation of the petitioners. Full stop. Accordingly, the learned senior counsel accordingly praised and is granted time to obtain complete instructions.
Right.
Full stop. Also heard to be gossip, learned standing counsel, elementary
Elementary.
education department. Full stop, Sarah. Please, after the vacation. Summer.
Please, your lord. Well, last occasion, your lordship directed me to take instruction whether SMC is there. SMC is not there at present, madam.
Have you been allowed to join or not?
I am working, they are paying salary. Only problem is they are not allowing me to put signature. Earlier president used to keep the register in his home because
Yes.
his wife was also there.
Now SMC is not there.
No SMC. Headmaster is looking after.
Now you are putting your signature.
I am getting regular salary,
Then
but without signature.
If you have some grievance, you can come. We'll record your statement.
My lord, kindly keep that direction
Yes,
to
yes,
the school headmaster to allow me to sign.
Yes, you are for
Correspondent 5.
headmaster.
Lord,
Headmaster's wife, president, he is no longer president.
He or no she. He or she.
He.
You are saying that you are the headmaster's wife.
No, headmaster wife is also there, my lord. She is also cook, but never come to school. Cook the kitchen.
Same case.
Yes. This
Well-
case also is there. Same case. No, that you hate to prepare like case. Here's a case. Now that president is no longer, headmaster is.
Even that case was Namasudra. What was the name? Namasudra.
No, that is your lordship disposed of.
Kalpana Namasudra.
That
Yes.
letter was disposed
Same
of.
family members.
Yes. No, not family member, but your wife has been put as a additional cook.
You are
Without work, my lord, she's drawing salary.
all the members are expert cooks or what? You are cooks in all the schools.
My lord, because in considering the strength of the
Two
student,
Namasudras in that school. Here one Namasudra again in this
you
school.
all Namashudra, in that area is a complete Namashudra area, my lord.
Third, Sri S.C. Biswas, learned counsel for the petitioner. Also heard Sri S.C. Elementary, P. Kaushik, and standing counsel Elementary Education Department, and Sri J.M. Suleiman for the respondent number 5. Madam, for SSA,
SSA, your lord. Respondent number
P. MSP Das has appeared for the SSA. Considering the subject matter and the development which have taken place during the pendency of the writ petition, the same is taken up for disposal at the admission stage. This writ petition, which is pending in 2019, is taken up. Pending in 2019 is taken up. The case projected is that the petitioner was engaged as a cook in the, what is the name of the school?
91, Deshbandhu LP Memorial Institute,
In the 191
191.
number Deshabandhu Memorial LP School, Keotkona, in the district of Karimganj.
Yes.
In the year 2006. Full stop. She had rendered her service without salaries for the initial 5 years. Full stop. The allegation is that the wife of the headmaster of the school, who never appeared and discharged her duties as a cook
Not headmaster, president.
of the wife of the president of the school, who had never discharged her duties as a cook, had, however, put her signature in the attendance register, and the petitioner was deprived of from putting her signature in spite of rendering her service. There were litigations earlier, being WPC 589/2017, in which this court had passed an order dated 3/2/2017 directing the authorities to consider the grievance of the petitioner and pass appropriate orders. There was also a contempt proceeding, being contempt case C number 447 of 2017, whereafter, the petitioner was allowed to discharge her duties and her salaries were also paid. However, contempt petition, two contempt proceedings, WPC 447/2017 and WPC, contempt case 447/2017 and contempt case C 53 of 2018, whereafter he can allowed to discharge her duties and also pay the salary. The petitioner, the three SC business counsel for the petitioner, however, submit that though at the time of filing of the writ petition, she was not allowed to function her duties, subsequently, the said grievance has been redressed and the petitioner is allowed to function as a cook and are also being paid the salaries. However, she is not allowed to sign in the attendance register. The council further informs this court that as per instructions received, the school is presently without a school managing committee and is under the supervision of the headmaster. Also heard three B Kaushik, standing counsel of the department, submit that the grievance of the petitioner has been substantially redressed and accordingly the writ petition may be closed. He, however, does not object to the prayer that the issue regarding signing of the attendance register may be directed to be considered and resolved. The aforesaid submission is also endorsed by MSP, the Learned Council for the SSA. This Suleiman, the Learned Council for the who are you? Headmaster.
I'm president. Region president.
Number 5 submit that the state response number 5 was the president of the assembly, which, however, is not functioning as on date, and therefore he would not have much role in this case. In view of the aforesaid facts and circumstances, and also the development noted above, that the petitioner is discharging her duties as a cook in the aforesaid school and also being paid her salaries, the headmaster of the school would look into the matter for allowing the petitioner to sign in the attendance register if the assertion made by the petitioner that she is discharging her duties is correct. Retribution accordingly. Now with the aforesaid directive, retribution can dispose of.
May it please your Lordship, kindly pass it out of
18 matter, madam. What is the matter about?
matter is about compassion of the conduct of the
Compassionate appointment. Who had passed away?
the petitioner's father.
What did he do?
He was assistant
Where? Yamaji.
in the
When did he pass away?
he passed away on 2014.
Yes, yes.
In the Lordship,
Petitioner says that her case was initially recommended by the district level committee,
yes, sir.
which
For
however
assistant-
was remitted back by the SLC for a new proposal,
yes, sir.
resubmission of the proposal. Why?
Yes. That in the PLC has recommended her case as for the assistant teacher. For that, her qualification is not there,
Okay.
not qualified for the post of assistant teacher.
Madam, what is your qualification?
BA, but BA in computer application diploma.
For assistant teacher, you need BEd also. What?
BA or PhD with a lordship 50% marks in HS, higher secondary lordship. as
Oh,
per
he was
notification.
lacking in that
Yes,
eligibility criteria.
yes, sir.
But
And,
she'll
and
be eligible for what post?
with PT and BEd also required.
BEd is required. That is it.
Yes.
What she'll be eligible for what post then?
Then lordship gets the lordship is subsequently lordship in her case and again lordship placed in that district level committee in 2017.
It was placed.
Yes, lordship. But as per instruction lordship, but at that time lordship it was not recommended due to non-availability of the vacancy. Subsequently in 2019 lordship, again her case has been placed in the lordship assistant teacher.
Hmm.
On 25 in 2019.
19.
Yes,
Okay.
sir. It's a minor lordship.
What was the outcome?
But again, it was recommended for the assistant post of assistant.
Same thing.
Same thing.
So she is not having the qualification.
Yes, sir. But PLC has recommended for assistant teacher.
PLC has not considered this aspect of the matter of qualification.
No, lordship. I think lordship remarks in WPC number 2008 lordship. That was not considered.
Yeah. Though delay is a factor, but at the same time, we cannot make a citizen run around.
Yes.
Once the DLC comes to a finding that she is eligible and recommends,
Yes, sir.
in spite of checking her eligibility, it gets remitted back by the SLC. Again, you are making the same mistake.
In 2019 lordship, same thing. And as per lordship, the action lordship, personal.
Now, after
leave
okay, after 19, what has happened? After the DLC has again recommended, what has happened?
That instruction lordship, I don't have lordship.
Again, it will be
Yes,
remanded back to the DLC to take a fresh decision, isn't it?
Yes, sir.
Because qualification.
As per her qualification in case.
So you are doing a futile exercise.
Yes, sir.
This exercise will.
Or lordship, I have to take instruction lordship after 2019 what the SLC has. So it was just before the SLC or not. That
Madam, we have the instructions for what has happened thereafter.
we'll have to take the instruction.
Are you aware that your matter was considered in 19 and 17?
No, sir.
In fact, before you had filed this application, you had given the narration only up to 2016,
Yes, sir.
14/7/2016, when the matter was remanded back, referred back. Thereafter, there are developments in 17
Yes,
You have
Lordship. in-
filed this writ petition in the year 2018 in June. You were not given, you have not disclosed the full fact. You
And-
take instruction.
29/4/2017 it was placed.
Written and for the writ petition was filed in June 18.
June, Lord.
18.
Yes.
More than a year thereafter. Your name?
SJ.
SJ. MS SJ, Learned Counsel for the petitioner, has submitted that this matter, which was filed in the year 2018, pertains to appointment on compassionate grounds. The case projected is that though there was a recommendation by the DLC in its meeting held on 24/5/2016, the SLC in the meeting held on 14/7/2016 had referred back the matter to the DLC for resubmission of the proposal. The petitioner's case is that thereafter no action was taken. On the other hand, MSD Das Borman, the learned state council, has submitted that after such that submitted that even before the writ petition was filed on 8 June 2018, there were developments which are relevant in this case and also subsequent developments. He submits that in the year 2017, the case of the petitioner was again considered, which however
would not be recommended due to lack of
which
evidence.
however was which however could not be recommended due to lack of vacancy. Subsequently, in 2019, the DLC has again recommended the name of the petitioner for the post of assistant teacher. The aforesaid exercise of recommending the name of the petitioner for assistant teacher would be a futile exercise inasmuch as, from the instructions which has been disclosed, it appears that even on the first instance, the matter was referred back only on the condition that the writ petitioner was not having the eligibility under the rule to be appointed as an assistant teacher, and it appears that the same it appears that the exercise done in the year 2019 has been made without considering the aforesaid aspect.
In the record, Lordship, at the time of record, that condition is not there, Lordship. Only that entire Lordship seat actually 10 candidates name has been recommended by DLC at that time, Lordship. Entire matter has been remanded back, Lordship, and stated that as per resubmission of as per personal B department OM, that is in page 34 in the decided to report
Referred back by referred back by taking into consideration the
Yes.
OM dated
1/6/2015.
1/6/2015 of the personnel department,
Yes.
personnel within bracket B department.
B department.
He would proceed, under the aforesaid circumstances, both the learned counsel for the petitioner as well as the learned state counsel are directed to obtain the instructions regarding the developments which might have taken place after filing of the case. put the list on 17th of July on the reopening. Come prepared, madam.
Yes, right.
So this is a matter where we have challenged at 22, we have challenged the amalgamation. Order it at page 19.
You are on 679 or 18.
Yes.
The
Yes.
first writ petition.
First it- When it was pending, Lordship, our representation was disposed of by a speaking order,
That you have put to challenge
challenge
in
again,
the second writ.
second it
Otherwise, the subject is on amalgamation.
amalgamation.
You are teachers of which school?
ME, Bisni ME Madrasa,
You are an ME Madrasa.
ME Madrasa,
Amalgamated with what?
amalgamated with Zakir Hussain Public High School. Basically, there is a policy for amalgamation. 16/9/2016, 22/9/2016,
What is it called? Shiksha Ketra.
which have been recognized by the Act itself, 2017 Act. My case is that the policy,
Who you are teachers of?
Bisni ME Madrasa.
Bisni M. Madrasa. How many petitioners are there?
Uh, in the item 22, there are 11 of them.
11 petitioners.
So what has happened? There is a policy. We are not questioning the policy. The policy is all right.
What is the OM dated?
OM dated 16/9 on
16.
22/9, 22/9/16, 22/9/16.
OM for amalgamation.
Amalgam. There is an office memorandum. It was challenged. It reached the apex court also, but it was upheld. Therefore, I am not questioning the policy. What I am questioning is that the policy
Yes.
is not to amalgamate school like us. The entire policy was
You want to contend that the conditions for amalgamation are not applicable to your school.
yes, because the entire object of amalgamation, as per the policy itself, was in view of compliance with the RTA. Now, if these two schools are amalgamated, it will violate the RTA. Therefore, this school, my school, cannot be brought into under this policy.
Yes, let us see. What are your grounds?
Lordship, there are, I may say, which have been duly recognized in the speaking order itself. That is, there are 340 students and 9 teachers.
You have 340 students.
340 students and 9 teachers. Lordship, at the first read petition.
Yes.
First read petition at item 21. If Lordship is page 31.
Yes.
At para number 4. That is the reason for amalgamation given. That is important.
Para 4, where page?
Second read petition, annexure E, page 31.
Second read petition.
Sorry, item 21. Lord.
6592.
Yes, yes.
Tell the petition number.
659.
Yes. Item
page 31.
Page 31.
31. That is the reason given for amalgamation.
Okay, this is the speaking order.
Yes.
Just a
At para number 4.
Para 4. Here,
Therefore, in the said hearing, it was revealed that both ME Zakir Hussain are located in the same building. The headmaster, Zakir Hussain High School, informed that presently there are 9 number of teachers in the school and total enrollment is 340 students.
in the high school.
Lordship, high school, yes, Lordship. At para 4,
Mm.
at para 4, Lordship, we have indicated our para 4 of the item to
Page 31.
yes, Lord, page 31. That is the strength of the high school.
High school. Yes.
High school in the ME school at para 5 of the same repetition 6592.
Yes.
We have indicated
Yes.
para 3 and 4, Lordship, para page 5, that the Bizni Madrasa was established in 1962 and has a total number of students of 401. The aforesaid madrasa is an ME madrasa and such there are classes from 6 to 8. Class 6 2 section 122 students, class 7 2 sections
You are reading
146,
page,
page 5
yes,
659,
paragraph 3.
paragraph 3 and 4. We have indicated the total number of students.
Bizni Ami Madrasa 62. Me 401 students.
401. And Zakir Hussain also, Lordship at para
Great.
4.
2 section. 2 section. Number of teachers 11.
11,
11 teachers.
including the contractual.
Yes.
Now, Lordship, because the reason cited in the sitting order is contained in the policy itself. Therefore, the reason is at page page nine reason. Lordship,
31.
yes, yes. It's a reason. Lordship, I'll just read it out. The reason.
Hmm.
It may be mentioned that the scheme section caterer issued through an office memorandum dated so and so by Secondary Education Department has the following criteria, namely that all the schools situated in the same campus shall be merged with the highest school or ME or LP. All of these schools situated in the same campus, all other schools shall be amalgamated with the high school. Then all other schools subordinate to the high school shall be amalgamated with the high school. Accordingly, it appears that the criteria under the scheme section has been fulfilled in respect of amalgamation of Bizni ME Madrasa with Zakir Hussain Public School, and the representation dated so and so by Saeed Ali has been examined taking into consideration all facts and figures. It shows that the representation has no merit. Lordship will come directly to the scheme. Lordship, I'll place the scheme and show that the entire object of the scheme at
13. 1 3.
yes.
Twenty-two 9 16.
Yes. At page 14,
1 4.
1-4 at clause 7. It is this reason what is cited.
No, this is not the reason.
No.
Reason is 1. 3 1.
Uh,
7 is who will be the headmaster?
yes, yes, yes.
1 1.
Yes, Lordship. All the schools situated in the same campus shall be merged with the highest school. Yes. Now your Lordship will turn to page 15.
1 5.
1-5.
Yes.
clause 5.
Yes.
There shall be one committee at the block level and the district level to find out the schools within the which are eligible for amalgamation merger in view of the provisions of the RTE Act and the norms laid down by RMS. Lordship, my case is that if ME Madrasa, which has 400 students with 11 teachers, and high school, which has 338 students with 9 teachers, are amalgamated, it will be in violation of the provisions of the RTE Act. Firstly. Secondly, Lordship,
What is the violation?
Lordship, I'll show. Secondly, at clause 7, that is clause 7, page 14, what I just pointed out.
Yes.
The scheme is that if suppose the ME school merges with the high school, there will be one headmaster who will govern the entire thing, and the principal of the ME Madrasa may be the assistant. That is the scheme. But the RTE Act, as per the schedule, it says that if a elementary school means 1 to 8, as per definition, has more than 100 students, there has to be a separate headmaster. So, if this scheme is applied to our school, there would not be a separate headmaster for the ME school.
So once there is an amalgamation, what is the scope of a separate headmaster?
Yes, Lordship.
And you have, at the outset, you have submitted that OM has tested the scrutiny even in the Supreme Court.
Yes.
OM has not been held to be in derogation with RTE Act. Now, if the OM says that this is the arrangement,
yes,
once after it is amalgamated, the headmaster of the ME school becomes the assistant headmaster of the amalgamated school.
Yes, yes.
Correct. Now, I think that point will not be open for you.
Yes, yes.
You can concentrate on the
this OM has to be read with the RTE Act.
the OM. The validity of the OM has been upheld by the Supreme Court. Can you
No,
say
no,
anything else?
validity I am not challenging it. I am challenging it that it has been wrongly applied. I will show the provisions also. Wrong application of this OM.
Yes. What is the wrong application? Just to us.
Lordship will come to the RTE Act first.
Where is it?
At the brown book, Lordship.
Yes. Tell us.
Yes, Lordship. Lordship would come to section 19. No school shall be established or recognized under section 18 unless it fulfills norms and standards specified in the schedule. Where a school before the commencement of the act does not fulfill the norms and standards.
This book does not have RTE Act.
This book does not have. It has it. These are the rules. Yeah, book. Lordship may take this. A yellow color character.
Yes, whatever contention you want to involve.
Yes, Lordship. Lordship, 19.3, where a school.
Okay, we'll come back at 2 o'clock.
Yes.
Okay. You try how big is the how thick is that act?
Small one. Lordship may take this book. I will only place
No,
the
we'll
schedule.
have a print out.
Brown book one আছে brown one আছে বড়
নাই আমার computer problem.
Lordship, I will bring it.
M. Ahmed, learned counsel for the petitioner submits that he has been instructed not to press this application. What am I it's an application? Report 39 on the I also heard will be appearing additional PP KK Das. Also heard KK Das additional PP also. It affects accordingly closed donor trial.
Hello.
Yes. KK Das.
But at the onset certified, if there are no pleadings have been exchanged, affidavit in opposition has not been filed in this matter. Therefore, I just not.
Yes.
But I was on clause number T1 of the policy.
Of the OM.
Lordship, I was on the RTE. Lordship has got this RTE.
Yes. Which one?
Yep.
Oh, no. Sure. When it? 2009
Okay.
Section 3
Section 19. I was on 19.
19.
19. Basically, 19.3 says that if we 19.1 and 19.3, no school shall be established or recognized who does not fulfill the standards and norms specified in the schedule. And if any school fails to fulfill the norms and standards within the period specified under 2, the authority prescribed under shall withdraw recognition. Now, Lordship, I wanted to place the schedule. Schedule is 39.
Scheduled to this act?
Yes, yes. Schedule.
Yes, please.
Real number 1 is the number of teachers and students.
Hmm.
At B2 and 3 main, where the admission criteria of children is above 100,
Hmm.
a full-time head teacher. That is one of my grounds. But Lordship, as per the policy,
Yes.
Lordship, when the students are more than 100, a full-time head teacher is required, headmaster. Now, as per the policy, if it is amalgamated, the ME madrasa will lose its headmaster, and the headmaster of the high school will take over it, 3-7. Therefore, Lordship, it will not suffice the requirement of this schedule, because otherwise it will now be around 700 students. It cannot survive with one head teacher, and this specifically says that
What is this kind of submission you are making, Mr. Bora? One school having 1,000 students will have 3-4 headmasters. This is 100 is minimum. Before you make a submission, try to be sane and reasonable.
where admission of children is above 100, a full-time head teacher. Lordship,
So, is it less than 100 after amalgamation?
yes, it will.
Is it less than 100?
Lordship will read 3-7 for one. 3-7.
You are saying that if there is more than 100, there will be requirement of more headmasters. Suppose there is a school having 1,000 students, They'll have 3 headmasters, 4 headmasters.
No, Lordship.
What is the headmaster?
Then ME Madrasa would not have any
So
headmaster.
it gets amalgamated into high school, part of the high school, there is no headmaster. Is it a situation where more than 100 students are there, there is no headmaster?
The headmaster of the ME school would become a headmaster, would become the assistant
So would
headmaster.
the
who will
school,
look
would the
after
school be, would become again, would be a head school without a headmaster?
There will be one headmaster of the
So-
high school.
How is this applicable? This says that if the students are more than 100, there has to be a full-time headmaster. Here after amalgamation, it's a question of not being less than 100. It's far more than 100. There is a headmaster of the high school who will function. How is this applicable?
Lordship, it says that where the
First, what is your right? Tell us. To prevent an amalgamation, what is your right?
Lordship, when the matter was filed, Lordship, we were members of the school management committee.
Yes.
School management committee, as per section 13 of the RTE Act,
Now, what is your right to prevent an amalgamation? To obstruct an amalgamation? Or to say that the ME school will function as it is without amalgamation? So, as some violation of the OM.
Lordship, OM, and Lordship, one more point. And high school and ME Madrasa cannot be amalgamated as per the scheme. I will show
So
on
that
Lordship will take up the scheme. The entire scheme was based on, Lordship, I will place the act itself. The entire scheme is based on enrollment and number of teachers. Lordship, if the enrollment is less than 40 as per the scheme itself.
so that where are you taking to 100 students?
Yes.
Where?
Lordship, at page
OM.
Lordship,
Yes, we have the OM at page 13.
at page 14.
Yes.
14 at 7, I'll just read out thereafter. Other thing. In the event the highest school is the highest school.
We have this 7. How is it applicable? The headmaster becomes the assistant headmaster of an amalgamated school. What is the difference? What is the problem you are having?
Lordship,
What right has accrued upon you to challenge this? Or what right of yours has been violated, infringed?
Lordship, school management committee as per the act has a place in elementary school.
You show us what right of the has been violated,
Lordship,
which provision has been violated.
Lordship, yes. Lordship, if 2 or more high schools are located within the radius of 2 kilometers, Lordship, that is if a ME school, 10 Lordship.
Yes.
If a ME school has 4 enrollment, less than 15 students is every class, then the ME school may be merged with the nearby high school. Lordship, then 13, similar criteria shall be considered in ME Madrasa, High Madrasa, and High Secondary School. Lordship, the policy does not contemplate a High Madrasa being amalgamated with a high school. It is another ground.
Yours is an ME madrasa.
ME Madrasa.
It's not a high madrasa.
No, it's amalgamation between an ME Madrasa and a high school. Lordship, if I read all the clauses, Lordship, it does not contemplate
Where is the amalgamation order?
Lordship, at page, the other petition, page 19.
Here.
Page 20. And here at page 20.
Yes.
And this is done as per now the scheme itself is recognized by the Act of 2017, which comes into effect from 5/5/2017. Now, this Act itself says that where there is a poor enrollment and the concerned authority has to give particular reasons for amalgamation. This amalgamation order does not contain any reason.
Where is the reason? Where is the requirement of reason? The policy decision.
No, Lordship, I'll place the Act 2017 Act. because it comes into force from 5/5/2017. It is done in 2018.
Yes,
12, page 119.
on 19.
In appropriate cases, amalgamation, merger, and shifting or expansion of educational institutions.
Hmm.
In appropriate cases, if there is already an existing education institution nearby and the enrollment of students does not justify for one more than one institution in the same locality, or there is any other sufficient reasons so to do, the state government, in the public interest and for reasons to be recorded in writing, may order the transfer of shifting of the institution and the incumbents of the institution from one place to another, or may order amalgamation or merger of two or more existing institutions as per the section scheme. So there is a requirement of an order where the authority has to show its satisfaction to the ground in the scheme. But if now the state may have any
Now see, this amalgamation order is only in respect of certain teachers.
Yes.
Who will be the ultimately affected parties.
Yes.
Are they before this court?
Lordship, that is one thing. Lordship, whether our legal right has been infringed or not. Lordship, the school management committee, as I will place Lordship, as per section 13 of the Act, has some functions to do. Lordship, if I can satisfy your Lordship that the school management committee,
Hmm.
as it then existed,
Hmm.
whether they can, their rights will be infringed or not. Lordship, that is another point. Lordship.
That is,
Lordship, school management committee at rule 13 of the rules, the rules of 2011.
which rule?
State rules, Lordship, 2011.
Venture. What
No,
rule?
RTE rules. RTE rules 2011. It is on the bare act itself.
We have the state rules also.
Yes.
This got central rule. State has formed another set of rules.
Yes.
Not this 2010 rule.
2011, Assam Right to Education, Child to Free and Compulsory Education Rules 2011.
Okay, this will be perimeter. Where which provision?
Made in exercise of the power conferred under section 38, the rule 13, 13.2,
13.
13.2.
Pretty late. We'll need your rec. Yes, please.
Lordship, one of the functions of the school management committee is to monitor the working of the
Yes, please.
monitor the working of the schools. Lordship. Therefore, Lordship, if
13. School management committee. 13.2. Function of managing committee. Yes. Monitor.
yes, but monitor on another thing, Lordship, mainly Lordship, now if
if it, Lordship, the members of the school management committee are also the guardians of the wards there. Lordship, if such an this is a reputed school of business, Lordship, with many students and adequate teachers, it does not require amalgamation. It can stand in its own, Lordship. Therefore, if there is an amalgamation done, Lordship, my humble submission is that the school management committee can bring it to the notice of this court, Lordship.
Bringing it to his notice and putting a challenge are different connotations. To put a challenge, you need to establish a prima facie that you have a vested right. Your rights are being infringed. If you are not taking care of the school, somebody else will take care of the school. What is the right of yours that you need to be continued in the SMC and your individual? Even the SMC as such, the body has not come before us. Today you are there, tomorrow you may not be there in the SMC also. Even in a given case where ME school is continuing. These are tenure posts for 5 years.
Yes. Correct.
Now, what apprehension do you have that after amalgamation, the ME part which got amalgamated with the high school and become a part of the high school, that part will be neglected, or the development will not take place, or there will be nobody to monitor the development?
Lordship, the entire amalgamation process is based on certain reasons cited in the policy read with the Act, RT Act also, Lordship, the 2017 Act also. If the reasons for amalgamation does not exist,
See, there is a scheme which has been given a statutory color at 28.
yes,
Now, the amalgamation is a part of a policy, it's a policy decision. The OM has given a statutory color in 28, I think.
Yes.
Now, they are implementing the statute case to case basis.
yes, sir.
Now, until you make out a prima facie case that this amalgamation is done in violation of this provision, that provision, you are not being able to. And at whose instance we are examining? At the instance of few members who are part of the SMC.
Lordship, now it does not contemplate a ME madrasa.
We have
to be
examined number of
amalgamated
cases where somebody's service was, at least there was an apprehension that it will jeopardize the service career. He'll not get a chance to become a principal or a headmaster because of amalgamation. We have dealt with those cases, but here, this school, there is no effect with the functioning of the school.
Now, Lordship, if the policy itself does not contemplate a ME madrasa to be amalgamated with the high school, and leave apart, Lordship, enrollment, the basic objective, Lordship, if I read the objective of the policy, it basically is to facilitate maximum utilization of the employees because of poor enrollment, Lordship, if I read out the policy, objective of the policy. And therefore, it does not contemplate a ME madrasa to be amalgamated to a high school.
Now, what has it got to do with utilization of the services of the employees?
Lordship,
With the status to a high school or ME school?
yes.
If you say that the policy is for best utilization of the services of the employees,
Yes.
based on the enrollment,
Yes.
how does it make a difference whether it's a high school or an ME school or an LP school? Or
But the policy has to contemplate it. Lordship. High school can be amalgamated with a ME school. High school cannot be amalgamated with an ME madrasa school. Lordship, now, and
But
high
what about-
madrasa can be amalgamated with ME madrasa.
What about 13? Similar criteria shall be considered in case of ME madrasa, high madrasa, and higher secondary madrasa.
Yes, Lordship. Lordship, to my limited understanding, Lordship, if there is a high madrasa and a ME madrasa, it can be both be amalgamated. Lordship, if I read the policy, at T1,
What is the name of the act? Where amalgamation has been inserted as twin.
It is called the Assam Education Provincialization of Services and Reorganization of Education Institution Act 2017. Now, Lordship, I wanted to show one more thing in the policy.
Just a minute. 17. Which page? Mr. Kaushik?
It's 119. 101, relevant is 119.
Prison. Okay. Okay. No, not this case. Where the poem was almost inserted. Shiksha Kshet-
Yes,
Kshetra.
Lordship, section
He
12.
refers to section 1219.
12.
But in my humble submission, this act will not be applicable because this
No, not this. There's another act where section 28, we remember, exact wordings of this office memorandum has been quoted. Statute came later,
2018 secondary
Yes.
well, that is
section 28, isn't
yes,
it?
Assam Secondary Education Provincialized
Yes,
School
yes,
Rules
yes.
2000.
Page.
Page 44.
Report.
Sorry, Lordship, I did not know that.
Yes, scheme for amalgamation of schools. See, same order, perimeter. Here, in fact, see, after in the statute, there is no discrimination or no difference between ME and MB.
In fact, section 28 subclause 1 manual indicates about the objective manual of this scheme. If the two schools are situated in the same campus, and this is a case manual where both the schools are in the same campus, in the same building,
Same campus.
same campus. So, lot of people can find the impugn order manual, the page 31.
Yes, Lordship, I already pointed out that. Even Kitchen import.
Page 31 manual, paragraph 4.
Page.
Page 31.
Yes.
WBC 659.
You are referring to the annexure, the amalgamation order.
Yeah, no, my lord, the speaking order which has put to challenge in the
Okay, 13 June.
after the amalgamation, he approached this court, my lord, and there was a hearing taken place. And this is the speaking order which
13 June.
yes, ma'am.
Page
13 June. Page 31.
Hmm.
From top, my lord, fourth paragraph.
Hmm.
In this said hearing, it was revealed that both the schools, namely Bizni ME Madrasa and Zakir Hussain Public High School, are located in the same building.
Same building.
The headmaster of Zakir Hussain Public High School informed that presently there are 9 teachers in the school and total number of 314 students. On other hand, the petitioner Sahid Ali informed that the Bizni ME Madrasa, there are 11 teachers and number of students is 400. And this was agreed by the IS Tirang. It may be mentioned herein that the scheme Shiksha Kshetra issued through an office memorandum dated 22/9/16 by the Secondary Education Department has following criteria, namely all schools situated in the same campus shall be merged with the high school or ME school or LP school. All of these schools situated in the same campus. All other schools shall be amalgamated with the high school. Then all other schools subordinate to the high school shall be amalgamated with the high school. So clause 1 of that office memorandum clearly provides that if the schools are in the same campus, the schools will be amalgamated and it will be amalgamated with the highest. So this amalgamation was done, my lord, invoking clause 1 of the office memorandum.
Mr.
at
Bora is trying to draw a distinction between amalgamation of an ME school with a high school and amalgamation
lord,
of ME school,
I'll-
ME madrasa with a high school
I'll take your lordship to page 15,
of the,
the OM, my lord.
Yes.
The writ petition, page 15.
yes,
Clause 10. It
Yes.
envisages a situation, my lord, if the ME school has less than 15 students, irrespective of it is not in the same campus, then there has to be an amalgamation.
Yes.
Now, my lord, this clause 13 makes an indication that there will be no difference between ME madrasa, high madrasa, and high secondary school. So all are kept in the same. And this OM, my lord, nowhere bars that ME madrasa cannot be barred with a high school, my lord. Because ME madrasa, the difference in a ME madrasa and ME school, the ME madrasa has an additional subject Arabic and nothing else other than that.
You mean to say that 13 will take care of the situation?
Yes, 13 will take care of it. In fact, your lordship will kindly come to the
But will not accept your submission that since there is no bar, we do it. There is no bar for many things. Can you do it?
but this clause 1, my lord, when it says
That is not a legal
Yes.
submission. There is no prohibition, so I do it.
no, my lord,
You can do it
clause-
only when you are entitled in law. You're permitted in law.
Well.
Only there is no negative clause, I can do it.
my lord,
The
Your
other
Lordship-
submission, of course, we will consider whether 13 takes care of the situation.
Yes.
But he is trying to distinguish between that is not a case of merger of a ME madrasa with an ME high with a ME with a high madrasa. It's an ME madrasa with a high school.
my lord, clause 13.
Yes.
The wordings of the clause 13, my lord, the similar criteria shall be considered in case of ME madrasa, high madrasa, and high secondary madrasa. So, my lord, it means that the ME school and there is no distinction done between the ME school and the ME madrasa. If lordship conjointly, if we read clause,
From where do you make this submission?
my lord, page,
Is there any explanation?
my lord, page 15.
15 we have said, we have
Yes.
read.
If we, my lord, if my humble submission, my lord, that clause 10, and if it is read with clause 13, my lord, conjointly. It does not make any distinction between the ME madrasa and the ME school.
And 10, if you go,
My lord.
you are not expressing any opinion.
My lord.
That the condition which has been laid down
My lord.
is that the enrollment should be 4 of less than 15
Less
students.
than 50. My lord,
Here-
this envisages a situation, my lord. If irrespective of clause 1, my lord, clause 1 that 3(1), these are the criteria, my lord, in the policy, my lord. That
Mm.
clause 1 says that if 2 schools are in the same school, then it has to be merged with the high school. Now, if there is a school, my lord, though it is not in the same school, but this school has a less than 15 students, then there is a scope of amalgamation under this.
No, there's a distinction.
My lord.
Here in clause 1,
My lord.
it talks about same campus.
Same campus.
10 doesn't talk about same campus. It talks
Yes.
about a nearby high school.
Yes, nearby. Suppose in a
The question of enrollment will come when the
Only when
amalgamation has to be done with a
in
nearby high school.
nearby.
When the schools are in the same campus, the
Then
question of enrollment will not come.
enrollment will not. Now, if your lordship will kindly find page 5, my lord.
How?
My lord, this petition itself is not maintainable because the petitioners who are they, my lord, they are the guardians, and some of the petitioners they were the members.
Where?
Page 5, para 2, my lord.
Hmm.
That the petitioners are the guardians of the students studying in Disney ME Madrasa, and petitioner 3, 4, 7, 6 are the members of the school managing committee. 4 members from the managing committee, and others are the guardians.
Five is the employee, one of the
Where have you stated?
My lord, page 5 of the
No,
reparation.
where have you stated 5 employees?
Lordship, I have just came across the petitioner number 5 is at serial number.
As a guardian, what do you have what problem do
How
you
is
have?
there prejudice, my lord? Because it's in the same campus. The
Lordship,
students are not.
Now, Lordship will come to C141 of the policy.
Hmm.
How we are school, how the school management committee is agreed.
The school management committee is not before us.
We are the members. Lordship.
Members are before us. Even all
Individual
the members come. Then also it's not a school managing committee. School managing committee is a legal person.
Yes.
You can come before this court. You have not come. We are testing this case at the instance of few members individually.
Lordship, before last line, Lordship, the SMC,
Where which one?
page 13.
Yes.
The SMC, SMDC of the highest school, high secondary school or high school or ME school, as the case may be, shall continue. Of all others, schools stands withdrawn.
However,
However, shall be reconstitution of 2 representatives
With
from
inclusion.
guardians and 1 from teachers of the each schools amalgamated. Now, by this policy, by this application of the policy, what I am trying to show that the members of the school management committee will also be affected. Their legal rights will also be touched upon by this implementation of this policy.
these are tenure posts for 5 years. Your role is to see the development. Do you have any vested right which cannot be forever, it will remain? And the management committee is not before us. Out of how many petitioners? 11 petitioners. Only 1, 2, 3, and 4 are
4
members. Rest are guardians. How is a guardian connected? Same school, same building. What prejudice are we suffering? Not to talk about legal prejudice. What is the difficulty practically you will be suffering?
But if our school management committee, present committee will be withdrawn, Lordship. That is one thing I wanted to point out, because Lordship has asked,
That's the part of the policy.
yes, Lordship, if this policy is implemented in our school, Lordship,
No, this policy is the part of challenge. That the SMC goes, a new SMC comes, we cannot allow this. Challenge this.
Lordship, what I am projecting is that this policy is for a different reason, not
Sorry.
for
Yes, we have given enough time. Judgment.
Lordship, not for a school of this type. Lordship.
We doubt your bona fide. Yes. Good.
But moreover, there is no pleading on behalf of the state. They have not.
We're deciding on the point of law. The speaking order is there. Listen.
And it is before, I think, the implementation of 2018 Act. Lordship, but Lordship, the respondents were referring to the 2018 Act. Lordship. It will come into force after publication on the official gazette. Lordship, now this 19 this amalgamation order is on 18 January 2018. Whether this amalgamation was done before publication in the official gazette or before the implementation of the 2018 Act, that is another question.
Statute has come later. We are not
Later.
going to the statute. There is an OM.
Is the OM
Which OM validity we had. It was tested before this court, went to the Supreme Court.
and it was up.
Yes, Lordship, that thing I have also annexed the judgment also, division bench judgment.
And the section 12 of the 2017 Act, my lord, that act will not be applicable because that act is only for the schools which are at the venture stage for the purpose of provincialization, and these are provincialized schools. Page 99. Sir.
Yes. Section 12 was, I think,
He referred to section 12, my lord. Because under this act also, my lord, there is a scheme of merging the provincialized school with a base school. And for this purpose,
this present merger of this is not under 12.
not under this.
And Lordship would see the object of the policy at page 13, Lordship. The object of the policy, Lordship would kindly see whether why I was stating about the utilization service and enrollment. Because it is the object of the policy. Does my school fit in with the object of the policy? Lordship, may I read? Page 13. The department is receiving various proposals for amalgamation of different categories of schools located in the same campus, which are
Mr. Bora, we are not reading this. We cannot waste our time like this. There are many other cases, important cases. Heard Sri BP Bora, Senate Council for the petitioners. Also heard Sri B. Kaushik, Learned Standing Council, Elementary Education Department,
Secondary.
Secondary Education Department.
I'll refer for both secondary and
Elementary is also a party.
Yes, because me and
Standing Council for the Education Department.
education.
Also heard MS RB Bora, Learned Standing Council BTC. No, doesn't matter. Both these writ petitions being connected are taken up for disposal by this common judgment and order. Full stop. While the first writ petition WPC 679 2018 has been filed challenging an order dated 18/1/2018 of amalgamation of the Bizni Kami Madrasa with the Zakir Hussain Public High School in the district of Bongaigaon, the second writ petition WPC 6592 2018 has been filed against an order dated 30/6/2018 by which the representation of the petitioner submitted in terms of an order of this court has been rejected. Please have your seat. While there are 11 numbers of petitioners in the first writ petition, there are 9 numbers of petitioners in the second writ petition. Full stop. Before going to the facts and the issue which are arisen for consideration, it would be necessary to record who are the petitioners. Full stop. In WPC, in the first writ petition, it has been stated in paragraph 2 that the petitioners are guardians of the students studying in Bizni Amis Madrasa, out of which petitions number 3, 4, 7, and 6 are members of the school management committee. Full stop. A similar statement has also been made in paragraph 2 of the second writ petition. Full stop. Para. The case projected by the petitioner is that pursuant to a scheme referred to as Shiksha Kshetra, the Bizni Amis Madrasa was amalgamated with the Zakir Hussain Public High School by a notification dated 18/1/2018. Full stop. It is the contention of the petitioners that such amalgamation was in contravention with the provision of the RTE Act 2009. Full stop. Para. It is the case of the petitioners that there were 401 students with 11 teachers in the Ami Madrasa, whereas the high school had 338 students and 9 teachers. Full stop. It is also contended that the infrastructure and library facilities are compliant to the RTE Act. Full stop. The petitioners allege submit that representations were filed against the aforesaid action of amalgamation, which were not considered in the proper perspective. Full stop. The the aforesaid amalgamation order of 18/1/2018 was which is the subject matter of challenge in the first writ petition, this court by an order dated 9/3/2018 had directed to submit a representation to the Commissioner and Secretary, Secondary Education Department for consideration of the case of the petitioner. Pursuant to the state observation, representation representation was submitted on 2/4/2018, which, however, was rejected on 13/6/2018. Full stop. Para. Sri Bora, the learned counsel for the petitioners, by drawing the attention of this court to the impugned order dated 13/6/2018, has submitted that the rejection has been done without proper application of mind and without taking into consideration the objective and purpose of the office memorandum dated 22/9/2016 on the subject of Shiksha Kshetra, which was a scheme for amalgamation and merger of different schools. Full stop. He submits that there has been violation of the state office memorandum, more specifically with regard to the requirement of a headmaster, wherein the numbers of students in a school is more than 100. It is further submitted that the amalgamation public merger is to be done from ME school with high school, which whereas in the instant case, an ME madrasa is thought to be amalgamated with a high school, which is not covered under the purview of the state office memorandum. He submits
High madrasa.
high madrasa. This is the high school, not high madrasa.
High school with ME madrasa.
Let's say ME madrasa. High school to high school. Go with a high school, go keep it. ME madrasa kona hai. Let's say that. This is not under purview. He submits that the school in question, that is ME Madrasa, had 401 numbers of students with 11 teachers, and the merger would be in violation of the RTE Act. Full stop. Para. The learned counsel has referred to section 19, within bracket 3. No, not 19. What was that section? To meet the norms and standards? Yes, 19 of the Act, which refers to meeting of norms and standards for a school. Full stop. Reference has also been made to the schedule of the Act, more specifically under serial number 1B 3, wherein it has been stated that when the children are more than 100, there has to be a full-time head teacher. Full stop. The Learned Council, Tripura, has also referred to the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act of 2017, more specifically section 12 thereof, as per which, reasons are required to be recorded in writing in case of amalgamation of an existing educational institution. Full stop. With a nearby institution. Full stop. The rules framed under the RTE Act, namely the Assam Right to Children to Free and Compulsory Education Rule, 2011, has also been pressed into service by contending that under Rule 13 within bracket 2, the function of the managing committee has been stated, which amongst others include monitoring of the working of the school. The Learned Council for the petitioners accordingly submit that in the present situation and facts and circumstances, the amalgamation was not at all warranted, as there was no reason and there is no justification for such amalgamation apart from not meeting the objective and purpose of the scheme for amalgamation. Para. For contrast, Sri P. Kaushik, Learned Counsel for the department, has at the outset questioned the locus of the petitioners. Full stop. He submits that none of the petitioners are either teachers or employees of the ME school, but are only guardians, and therefore that no legal right of theirs is affected by the amalgamation. Full stop. Though he further submits that though 4 of the petitioners who are guardians have also been stated to be members of the assembly, the tenure of the assembly being for a limited period, and the objective is to see the monitoring of the school, no legal right appears to have been infringed. With regard to the contention made on behalf of the petitioners that after amalgamation, comma, it would be the SMC of the high school would prevail for the time being, comma. He submits that apart from the inbuilt provision which contemplates that in the subsequent SMC, comma, there would be representative of the school which had been merged, comma, the entire scheme was unsuccessfully challenged in before this court, which was also dismissed, and the appeal was also dismissed by the Honorable Supreme Court. He therefore submits that even otherwise, the contentions made by the petitioners are not available to them. Dealing with the submissions made in a specific manner, comma, the learned counsel for the department has submitted that reference to section 12 of the Assam Educational Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017 is misplaced, as the said act is primarily for the purpose of provincialization of venture school, which is not the and is not connected with the instant case. On the other hand, comma, he further submits that amalgamation oblique merger and shifting or expansion of educational institutions appearing in clause in section 12 only applies to a venture school and is not applicable in the amalgamation of institutions which are already provincialized, and therefore the requirement for recording reasons in writing will not arise at all. He otherwise submits that the entire amalgamation has been done in terms of the office memorandum dated 22/9/2016, the validity of which was also upheld by the Honorable Supreme Court. By drawing the attention of the OM, the learned counsel has submitted that as per paragraph 3 within bracket 1, comma, all the schools situated in the same campus shall be merged with the highest school. It further states that the SMDC of the highest school shall continue and the SMDC of other schools will be withdrawn. Full stop. However, comma, as indicated above, there is a mechanism for inclusion of representative of the ME school, whereby it has been stated that the SMDC shall be reconstituted with inclusion of 2 representatives from guardians and 1 from teachers of each school amalgamated. With, uh, uh, with regard to the submission that there is no reference to a situation for amalgamation of a ME madrasa with a high school in the OM, the Learned Standing Council submits that the aforesaid position is clarified by paragraph 313, as per which, similar criteria is to be considered in case of ME madrasa, high madrasa, and higher secondary madrasa. Full stop. Para. The contention was now a contention was made on behalf of the petitioner with regard to the provisions of paragraph 310, which lays down that only in case when the enrollment is poor, that is less than 15 students in each class of an ME school, the same may be merged with a high school. The said contention, however, has been refuted by the Learned Standing Council by submitting that the same is misplaced, inasmuch as para 310 has to be read with paragraph 3.1, full stop. Whereas paragraph 3.1 lays down that all the schools situated in the same campus pool shall be merged, paragraph 3.10 lays down that a ME school with poor enrollment of less than 15 students may be merged with a nearby pool, high school. Full stop. He further submits that in the instant case, both the ME madrasa and the high school are not only in the same campus, but in the same building itself. After hearing the parties and on consideration of the materials on record, this court is of the considered opinion that a present of this nature made by certain guardians of the school, of the ME school, is not maintainable, has no legal right, whatsoever, of a guardian of a student is involved by amalgamation of a school, of the school in question with the high school. So, four of the petitioners, four of the guardian petitioners, namely petition number 46, petition number 4 are also members of the SM, were also members of the SM of the ME school, there is no vested right to continue in the same capacity as members of SM, as the SMC itself is of a particular tenure. Full stop. Further, comma, paragraph 3, within bracket 1 of the OM dated 22/9/2016 makes it clear that on such amalgamation, comma, it is only the SMC, public assemblies of the highest school, which is the high school in the present case, shall continue, and the SMC of other school would be withdrawn, and such SMC, public assemblies, would be reconstituted with inclusion of 2 representatives from the guardians and 1 from teachers of each school's amalgamated. Full stop. This court has already recorded that the validity of the OM dated 22/9/2016 has already been upheld by this court and also affirmed by the Honorable Supreme Court. Full stop. Para. This court also finds force in the argument. Although this court is of the opinion that the writ petition in its present form filed by the present petitioner is not maintainable, comma, since the petitions are pending since long and arguments advanced on marriage, comma, those are also dealt with by this court. Those are also being dealt. Those are also dealt with by the court as hereunder. This court finds force in the argument made on behalf of the department that the Act of 2017, which contains clause 12, as per which reasons are to be recorded in writing for amalgamation, is not at all applicable in the instant case, as such amalgamation is for schools in venture stages and not schools like the present one, which are already provincialized. This court also finds also does not find any force in the contention that there would be any prejudice caused to the school in the terms of monitoring and functioning as an SMC public assembly would always be there for the amalgamated school. Full stop. This court also finds that the contention made that there is no provision of amalgamation of a ME madrasa with a high school is misplaced, as the position is clarified by paragraph 3 within bracket 13 of the OM. In any case, comma, the objective of the OM is to implement a scheme for amalgamation and there be a clear guideline for schools situated in the same campus to be merged with the high school, comma, this court is unable to accede to the prayer made in the writ petition. Full stop. In view of the above, comma, both the writ petition stands dismissed. No order.
Highly
This will return after some time, maybe tomorrow. Please. No, Yes.
So in this case, the
Uh,
petitioners are employees, my lord, of a mixed medium school lordship. My lord, that was the initially, my lord, Bhansar school lordship, and it was provincialized under 2011 Act lordship. My lord, only, my lord, one part, my lord, Bodo medium and Assamese medium, two parts here are there. Administrative head is, my lord, common. My lord, only Assamese part has been, my lord, provincialized lordship. It is admitted by the, my lord, BTC has filed affidavit lordship, saying that the recommendation was done, my lord, that Bodo medium staff have not been, my lord, provincialized lordship.
Mr. Talia, you are waiting for long. Which matter? If you can, if you want, you can upgrade your matter. We'll take up Mr. Talia's matter. Oh, you are for the respondent. Then you have to wait. Who is for the petitioner? Which matter? 25. Nair will be here. Then ask him to come. We don't want a senior counsel to remain sitting. Yes.
Lordship. My lord, the BTC has filed affidavit lordship. It is admitted by the BTC that the recommendation was done for both the units lordship. Only Assamese unit has been, my lord, provincialized, my lord. The Bodo unit has not
Director
been-
BTC has education has filed affidavit.
Yes, lord. Education not filed lordship, but BTC has filed lordship. That is response number 3.
That is it. He is the director of education.
Yes, lord.
You have admitted.
Lordship, we have sent to the education department for
You have sent to the education department. Yes, who is for the education department?
Second.
This is secondary, isn't it?
secondary.
Sharma, you are for secondary.
For
You have any idea of this matter? Sorry, you are there.
Yes, he has filed affidavit.
You have sent to the education department.
My lord, paragraph 8, 9, and 10, lordship. I said, legally
Sorry?
admitted, lord. Yes, my lord.
You have sent to the education department. They have to take a call now. Decision has to be taken by them.
Yes, my lord.
Yes, Mr. Sharma.
Right now, I have not given any instruction, my lord, here. So, my lord,
18 matter. When did you file the affidavit?
regarding
Oh, you have filed affidavit recently, 14 June.
14 June.
You take the instructions. And if they have sent the proposal, why don't you act upon it? Act upon it, finish the matter. How many of you are there?
40.
How many of you are there?
My lord, 3, lord.
3 petitioners.
Yes, yes.
No, not 3 petitioners, 5 petitioners.
Oh, lordship. Lord, 5 petitioners, lord.
Yes, you take the instructions. We'll record that. Have you been served with a copy of the affidavit? Musari, you give a copy to your colleague. You have served upon Mr. Ahmed?
Not start yet.
It appears that the Director of Education, BTC, has filed an affidavit in opposition on 14th of June 2023, in which it has been stated that
Paragraph 8, 9 and 10. 8 and 9.
That the decision to provincialize the school in question, namely Ratanpur High School, only for only the Assamese medium staff was taken by the Director of Secondary Education, Assam. Para. That it appears that a copy of this affidavit is yet to be served upon the Learned Standing Council of the Education Department, Para. Sri Mushari, Learned Standing Council BTC, has submitted a copy to Sri U. Sharma, Learned Standing Council Education Department, in the code itself. Let instructions be obtained by Sri Sharma from the department regarding the response to the stand of the BTC. Please, when? Today? We'll have it on 19th of July, fixing a date. Enough time you have. Immediately after the vacation.
Maybe other day lordship, except 19 law.
Tell us, 19 you have difficulty. On 21st?
No.
21st July.
All right.
Got it. Meet the data for this.
My lord, we are the LP school teachers, my lord. And as per
Petitioner is a singer.
my lord,
You are a singer.
LP school teacher, my
Your name is Udit Narayan.
yes, my lord. To that extent, I'm a singer.
You have come all the way from Darbhanga to do this case.
My lord, as per the ROP 2010,
Yes.
as well as 2017, my lord, we were given the equal pay scale.
How many of you are there? One.
No, my lord, we have, my lord,
Yes, what is the
we have
response, Mr.
124.
We have,
Lordship will be filing an affidavit regarding this.
you are for which department? Finance
Finance,
department.
Lordship.
18 matter, why haven't you filed? And education, you have also not responded. We need your response, both of you. Let them file their
My
response.
lord,
It appears that response are yet to be filed by both the finance department and the education, within bracket what? Secondary, elementary department. Full stop. Sri M. Bhuya, counsel for the finance department, as well as Sri P. K. Bora, the standing counsel, education private elementary department, pray for and are granted 4 weeks time to have to obtain the instructions. Let's file affidavit in opposition. Please go to 4 weeks. এখন না লাগে।
It is the lordship. Timing,
Actually, I was taking time.
Taking time.
No,
File response or not?
Yeah, look, actually, they have not filed a detailed response, reply. They have only filed a reply in 2 of the cases to the extent that we are not eligible.
What is your case?
Your Lordship, my case is that these people are working in grade 3 and grade 4 in various colleges throughout the state of Assam. Now, they have been appointed way back in 92, 95, 2000 at various points of time, and they've been working for more than 30 years, 25 years on a fixed consolidated pay. Now, the appointment was made because there was a need to make appointment of the staff.
in the non-teaching category, and
Mm.
they were appointed in the non-sanctioned post.
Mm.
Now, what was the basis was that people were appointed and they regularized on the basis of seniority, which my respected senior will agree to that. The college used to do that, which they filed an affidavit.
Mm.
But when our turn came, that was stopped because of a memorandum which says that no person working in a non-sanctioned post can be regularized.
Mm.
But that was with respect to the professors and the assistant professors and the lecturers,
Mm.
not in respect to the grade 3 and the grade 4 employees. So in this case, we don't stand on that, but we say that similarly situated persons have been done in the past, and these persons have been working more than 30 years. So they have
What
a
do you
legitimate
say?
expectations, your lord.
Our stand is that madam, they have been working in a non-sanctioned post, madam. And,
No, have you put your stand on an affidavit?
No,
Mr. Talia, you're for the college. Decision is by you or the department. The decision which would be taken by you or the department. Government college. Now I think provincialization or whatever regulation is has to be done by the department.
yes, your lord.
Okay.
Your lordship,
You will not have much of a role, I think.
they can only forward my names, your lordship.
Forwarded in him.
in one of the petitioner, we have filed affidavit in 8846 of 18, madam. That
Will it cover all the repetition?
yes, madam. Because all are working without valid sanction post, madam, and they are seeking regularization.
So you tell us, we'll have fixed this
and-
matters.
And their judgment,
If-
madam, which says that
Your lordship, I'll just like to vary from my learned friend's view. He has filed the affidavit in two cases. The only stand they have taken in this affidavit is that you are working in a non-sanctioned post.
No, if he's sanguine about the affidavit, let us
Yes,
proceed with
yes,
the
yes,
affidavit.
yes.
You can point out the shortfalls, whatever. We'll
Right.
fix this for admission hearing.
Yes.
When?
okay.
For all the matters are similar.
Yes,
Yes,
We can have it immediately on the way, reopening. On 18th itself, we can have. 18th or 20th.
July.
18th or 20th. Hearing day.
Can it be on 20?
20.
Not inconvenient.
Okay. The learned council are in agreement that the matter can be taken up for admission hearing. Full supply, as the learned standing council for the department submit that the affidavit filed in two cases would also cover the other case, as the point involved is identical. Full para. Also her DP Talia, learned senior council, appearing for the which college in so-and-so college, which is a respondent in WPC 8846-2018. Bora, you are also appearing. Okay. Assisted by 3PK Bora. Mr. Kumar, in which number? 8817. Kushal Kalita, Tulan Sharma, Kushal Kalita, V. Kumar. Now we record on V. Kumar for respondent number 8 and 9 in WPC 8817. For Kapara. As agreed to by the parties, please on 20th of July
Yeah, lordship.
for
I'll just
admission.
make a request to lordship. Let them produce, because my specific stand is that they have been regularizing all the teachers, all the
See, we have given it for final disposal. We have indicated. Whatever they want to produce,
no,
they'll
the
produce.
records,
Otherwise, we'll draw adverse inference.
your lordship, the records will reveal that they have been regularizing the services of the non-sanctioned working.
See,
in the
you are making an
non-sanctioned.
assertion. If they are not refuting, we'll say, hold that these are correct. It's up to them.
Negative equity.
Try to obtain the record.
Deeply obliged, your lord.
Yes, you had made some request in the morning.
Yes, may I pay the lot?
You want some time
Yes, the lot.
for?
We were directed to file additional affidavit, your lordship. So the person, the petitioner, he is in direct query. Due to the problem of communication, he couldn't come.
Okay, there's some flood you had said.
Yes,
Okay. Your PDAS.
PDAS.
Mr. Purkas, you for? And for the department? ZDAS. MSP does Learned Council for the petitioner submit that do an additional affidavit was to be filed by the petitioner, comma, due to the current floods in our, current situation of flood, comma, the petitioner is unable to come to Guwahati for executing the affidavit. Para. The also heard Sri G. Das
Yes, sir.
Learned, sorry, S. Das Learned Training Council Higher Education, Sri B. Purkas for the response number 3. Yes, Bhuya for and MSM Bhuya and Council for the Finance Department. For the para. In the interest of justice, list of 4 weeks to enable by which time the affidavit, the additional affidavit may be filed by the petitioner. Is there any interim order?
No.
Yes, next. Yes, madam, what is this?
In this case, my lord, I am no more in this case. My client has engaged other.
Who's there?
My name and Learned Council HRS Chaudhary. We are no more in this case.
Okay. At the outset, comma, MSM Malik, Learned Council submits that do he with a senior HRS Chaudhary was earlier engaged by the petitioner, comma. The brief has been taken away and presently, your name?
Here,
G.R. Dutta has been engaged, who is also present in this court. Registry is directed not to reflect the name of Sri H.R. Chaudhary, MSM Malik, and M. Pathak, and MSM Pathak in the court. Yes, Mr. What?
Obligement.
Wait, please, your lord. If I'm for the petitioner, in this case, your lordship, the student had enrolled for an MBA course under Guwahati University in the year 2014.
2014.
For her degree was MBA B, Master of Business Administration in Business Economics.
Use the microphone, not to speak loudly.
Thereafter, during the in the normal tenure, the rule is that under Guwahati University, a student gets 2 years for completing her course.
Extra 2 years.
No, 2 years is the normal period,
Okay.
and if a student has not completed her exam within this 2 years, he will get another 2 years. So, in this instant case, what has happened is that the petitioner had cleared her first 3 semesters in her normal.
How many
period.
semesters? 4 semesters.
4 semesters.
Okay, 2 years course.
2 years.
You have completed 3 semesters.
3 semesters she had completed,
Hmm.
and during the final semester, which is the 4th semester, she was able to complete 4 papers out of 6. And thereafter, what has happened is that Guwahati University has a situation where if a student has not completed within the 2 years, you will a student gets an additional 2 years for completing the rest of the papers.
You said so, yes.
So during those 2 years, she was able to complete the rest of the papers except one paper. So what had happened is that
In the extended period also, you could not complete all the
all
papers.
the papers,
One was still left out.
one was still.
Thereafter,
Thereafter, I had made a representation to the Vice Chancellor on 25th of May 2019
Hmm.
to let me appear for the examination that was supposed to be held on 3rd of June.
Hmm.
So, I did not get any reply based on the representation, and therefore the writ petition was filed. And based on the order of this Honorable High Court, by an order 55/2019, I was allowed to appear in the examination, but the the result will be declared subject to the outcome of the writ petition. So thereafter, I appeared in the examination, but the result has still not been declared. So my right, which I am emphasizing in here, is that there is a, if your lordship may please turn on to page number 14,
1-4.
the writ petition.
Yes.
So there is a UGC guidelines on the determination of a uniform span period within which a student may be allowed to qualify for a degree.
What is this?
It starts on actually page number 13. The
Yes. 14, guideline.
Yes, guidelines, your lordship. Your lordship may see paragraph number 2,
Yes.
B clause. It is written, in exceptional circumstance, a further extension of 1 year may be granted. The exceptional circumstances may be spelled out clearly by the relevant statutory body concerned of the university. So I am trying to emphasize that this is a situation that falls under exceptional circumstances, and because the situation was that my mother had been diagnosed in the year 2004 with acute blood cancer, and therefore she was terminally ill. And during this period of my fourth semester, that period, she was paralyzed. She had a paralytic attack, and then I had to go to Chandigarh to serve her. Like, no, I had to go to Delhi and come back. So there was a lot of. So I was totally serving my mother during that period of time, and still I appeared. Somehow I still managed to appear, but I was not able to clear. It's not that because I was a bad student, but the situation and circumstances were not in my. But still I tried, and if my previous results can be seen, so it shows that I have cleared all the papers previous. So for one exam, Your Lordship, I'm not allowed to.
See, this is an exceptional circumstance. It's a matter of discretion.
Yes, yes.
But the exceptional circumstance, to explain it is for the university. And to facilitate that, you have to apprise the university what are those exceptional circumstances. In the petition, where have you stated? Where are the documents?
Documents is not been annexed to Lordship, but my mother. You can see the representation which I have made on 25th of May 2019.
See, the representation you may write many things. What are the, where are the documents? Where is it in the pleading? Which part of the petition?
Pleading here. Your Lordship may turn on paragraph 5. There is page number 4.
4. Yes.
The petitioner begs to state that her mother was suffering from acute blood cancer since 2004 and repeatedly hospitalized at PGI Chandigarh, and she had under regular medical treatment. In 2017, condition of her mother became critical, and she was admitted in the hospital for regular treatment. Thereafter, in February 2018, she had undergone bone marrow stem cell transplantation. Subsequently, in April 2018, due to medicine reaction, her mother suffered paralysis in body and brain. Finally, mother of the petitioner, after a long regular medical treatment, died on 6/4/2019. It is pertinent to mention here that the petitioner is
At that point of time, your father was in Assam.
father was in Assam. He
Posted.
was yes.
You are otherwise from Chandigarh,
No, right now I am residing in
Silchar. You are a domicile of which place? Chandigarh.
Yes.
You have not given any documents in support of your averments in paragraph 5. These are very serious averments.
Your Lordship.
Mr. Fukan,
I take your Lordship straight to page 14.
first let us come to the that development which has taken place in the court. She was allowed to write the examination, and with the direction that you put it in a seal cover. Have you evaluated the examination?
I don't have that.
Is it there? You take the instructions. What is the state of the paper? Is it clear or not?
I don't think,
If she has failed, then perhaps we will not even adjudicate this matter. If she has passed, then perhaps we may have some other view. And we give an opportunity to the council to bring on record the relevant papers. Because exceptional circumstances has to be taken in an exceptional way. And it is up to you to state that why have you allowed her? Here you have not allowed her. It's the court which has allowed. It's not an exceptional circumstance. You are yet to evaluate and assess the situation, whether it was an exceptional circumstance. Now, to facilitate that, since this matter is before the court, at least the court be satisfied that there were reasons beyond his control or her control and good enough for which may require an extension.
I don't think.
Three, GR Doctor, Senate Council submits that pursuant to an order dated, which order? Was it at IA or this case?
It's a repetition.
There is
35
31/5/2019, comma, pursuant in interim order. No? The petitioner was allowed to appear in the paper of derivative and risk management, inverted comma, which is a part of the fourth semester conducted by the Guwahati University. Fourth semester of the MBA examination conducted by the Guwahati University. The court, this court had, the court, not this, the court had further observed that the result of the same, however, was not to be declared without the leave of the court. The learned counsel has submitted that in compliance with the said order, comma, his client was indeed allowed to appear in the state paper. Full stop. Reference has also been made to the UGC guidelines on determination of uniform span period within which a student may be allowed to qualify for a degree, page 14, under which, comma, the body concerned of the university has been given the discretion to grant a further extension of 1 more year under exceptional circumstances, which are, however, required to be recorded. The learned counsel has referred to the readings made in paragraph 5 of the writ petition regarding the terminal illness of her mother, who had ultimately passed away on 6/4/2019. However, comma, no document have been annexed in support of such pleading. Under those circumstances, comma, this court, comma, in the interest of justice, deems it fit to adjourn this matter by 2 weeks to enable both the learned counsel for the petitioner, not learned, but to enable the petitioner to bring on record the relevant documents by way of additional affidavit, and also to enable Sri Fukan, the learned standing counsel, Guwahati University, to obtain instruction with regard to the outcome of the examination which the petitioner had appeared pursuant to the order dated 31/5/2019 passed by this court. The evaluated answer script or any document from which the result can be known be placed before this court by way of a seal cover. Placed on, we'll have it on 24th of July. Enough time. Bring it. Okay. You are for whom? UGC. What is your name? B Das. B Das for UGC is also present. Reported. Yes. Absolutely. Good.
Please, your lordship. What certain instructions are required to be taken from the client, after which we'll file the affidavit. So the
You have to
matter may
file affidavit. Is that us? Who are you?
I'm for S1 number 4, your lordship.
For who's
The
for?
private S1, your lordship. I'm working, lordship, as the I've been
And
appointed, lordship.
who's for the department?
Tezpur University, lordship.
Tezpur.
Correct.
Who appears for Tezpur University? Aid us.
Lordship, first, Aid us, lordship.
Aid us.
Lordship. Aid us.
Mr. Das?
Oh, lordship, now central government been, lordship, all the inquiries
CCC,
are under the central
NSCGC,
government.
NSCGC, central government. You are a central government council. Yes, there is Tezpur University. Perhaps nowadays you will be appearing. Tezpur University. You will get the instructions, affidavit filed or not?
no, your lordship, certain instructions are to be
1, 2, and 3 has filed affidavit.
Yes, lordship.
4 you have also filed affidavit.
3 or 3 are filed.
may take it after.
After? Why 19 matter, madam?
That's right.
Mr. Das is appearing, still appearing or not? B Das? So, I mean B Chaudhary.
First, lordship, has to take it.
Names shown or not?
Because, lordship, he has filed this affidavit, lordship.
Names not shown. You are M. Kolita.
Yes, your lordship.
MS M. Kolita, Leonard Counsel for the petitioner. Praise for an adjournment. Full stop. 2, 3, DJ Das. Leonard Counsel for respondent number 4 is present, comma. And is present for the Tezpur University. Full stop. The records, however, reveal that the Tezpur University has entered is represented by Sri B. Chaudhary, who has also filed affidavit, whose name, however, is not reflected in the cause list today. Full stop. This immediately after the vacation by reflecting the name of Sri B. Chaudhary for the Tezpur University.
Much obliged, your lordship.
Mr. Mahmood, you are waiting for long. Which matter? 68. 68 will not reach. What is it?
Regarding music, appointment of music teacher at Kokrasar Government Higher Secondary.
Who is for the other side?
We have a RD production like
You have for who is for a private respondent? Oh, Madam Fukan. 2 to 5, your name is shown.
lordship, may I inform?
We may not have time. What is the issue, Mr. Mahmood?
Issue, my lord, there is a requirement of a B music teacher at Kokrasar Girls Higher Secondary School. Then, my lord, I was appointed in the year 2014. Before that, I had 10 years.
You are a B music teacher.
I was already teacher.
No, are you B music?
My lord, yes.
You have the B music.
Last requirement I do not fulfill.
What is
But
the last
she also
requirement?
does not fulfill.
What is the last requirement?
That music teacher should be B music.
What is your qualification?
I am B music.
Then
But they say that I have not 50% marks. That is the problem.
oh, the marks.
Mark. Now the private respondent has no marks. She is not B music. She is also not qualified. But I have experience of 24 years.
You are B music, but less than 50% mark.
Yes.
She is not a winner B music.
No, she is not B music.
Okay. Then you want to say that you
So
are
I was a teacher. So
you are better placed than the respondent.
better. Yes, that is the case.
Who is for a private respondent? Private respondent, who is there? Respondent number 7, H.K. Gogoi. Who is H.K. Gogoi? Madam Bora? He has contended that there is a requirement of B music with minimum marks. He is a B music, but he does not possess the minimum mark. But you have preferred a private respondent who is not even a B music. That is the allegation.
Lordship, I have filed an affidavit. Lordship, kindly verify.
What have you said?
I have said that music
Now, are you disputing this proposition factually?
of Sangeet Visharad is as per notification.
Yes, Sangeet Bisharad. That is B music equivalent.
Not equivalent.
Lordship, I
Degree,
have annexed the document
degree
notice.
can be provided only by university. And she has passed from board. That is diploma, not degree.
Kindly peruse my annexed.
But if it is equivalent,
No,
Notification.
equivalent, my lord, that equivalent.
if
how
there is a
we can-
notification, how can you?
we have enclosed the entire list of all India university and deemed university. That Jharkhand Institute in UP, that is not the university, nor a deemed university. So how can they can do that?
Kindly peruse notification.
But if it's a Bisharad is as
No,
you,
Bisharad is not enough. It will be music.
let us see the
Bachelor
notification.
music.
Where is the
This
notification
is at page 74, running
of your affidavit? 74.
is equivalent to
This notification is by whom?
notification by Secondary Education Department.
74.
Annexed F.
Yes, this is by the Education Department. Yes, please read.
Third paragraph. Whereas the matter was
Past and the qualification of HSLC. Past and Sangeet Visharad from Bhatkhande Sangeet Vidyapit for the post of music teachers of recognized higher secondary and high school appointed shall be accepted as a very special case and one-time basis for the purpose of provincialization. This is a higher secondary school.
It is.
When was
higher
your
secondary school.
Government has sent
when was your the respondent private respondent provincialized services? When was it? No, her service.
It was provincialized much earlier. After provincialization, that requirement was that music teacher should be appointed. Now they
No,
have
not the school. The benefit of provincialization given to the private respondent. When?
they have not annexed even
2000?
Interview held on 28/7.
they have not annexed appointment letter, at least not provided to us.
Now, therefore, in exercise of powers conferred under so and so, the qualification of so and so for the post of but this is prior to 1/1/2006. What is the meaning?
Yes, the appointed prior to 1/1/2006 shall be accepted as very special case. That also is special case.
And one-time basis. It cannot be a general.
And that too after 2006.
You know who's Mr. H.K. Gogoi? Any idea?
It is not so clear. Clear actually. For another. And my lord, I have, prior to my appointment, I had 14 years experience. And thereafter I was working. And I am B music from Guwahati University. From Guwahati University. Only marks are less. My university, it is maybe St. Melo, that is
See, here is
page
a,
23.
madam, here is a situation where we have a petitioner with B music. Maybe he secured marks less than 55 out of 50.
In BA, is the BA
BA is required.
Yes,
Where-
I am BA. Plus 23 can
BA
list.
and BA and in music 50%.
Understood. He is at least a B music.
Music
And the private respondent is not a B music. You are trying to make her Bisharad equivalent to B music by on the strength of a notification which was issued under exceptional circumstances as a one-time measure. Don't you think that the petitioner has been deprived? So we'll have it again on next week. Every day will be okay. Next Monday. Heard the ME Mahmood Learning Council 68 for the petitioner. Also heard MSRB Bora Learning Training Council BTC, who has also filed affidavit in opposition. MSN Pukan Learning Training Council Secondary Education Department is present. Who is there in the secondary? U Sharma. U Sharma. Training Council Secretary Education Department is present. None appears for the response number 7. In spite of the name of the learned council shown in the causes full of para. In the interest of justice, place this matter again on 26 Monday.
Maybe listed as part.
No, not part. Yes, what is this? No response file.
No response
Yes,
filed.
where are you?
Notice was issued on 5th of August.
5/8/2019. Thereafter, matter has not come. Why?
The accounts are also not being filed. Finance and
Yes.
secondary education.
Grant you time. This matter, which is of the year 2019, has been listed for the first time since 5/8/2019, when notice was issued for para. Both three M. Bhuya. No, don't say M. Bhuya first. Both three U. Sharma, Understanding Council, Education, Secondary Education Department, as well as three M. Bhuya, Learned Council for the Finance Department, praised for and are granted 4 weeks time to file the opinion of it.
May this matter relates to compassionate appointment matter. Melo, kindly see the order dated 5/8/2023, Melo.
5/8.
Oh, yes, Melo. Honorable Court is inclined to invoke the doctrine of non-pleasure, Melo. Since the respondent authority has not filed affidavit. And
5/8.
2023, Melo.
23. 5/8.
Sorry, sir. 8/5, Melo.
Yes, you have for whom? 7, you have filed affidavit. You are the appointed candidate.
Yes.
You are working.
Yes.
And department, I think this is compassionate. Madam, your role is there. What do you say? Come this side.
Yes, sir. So in this case, Lordship, instruction awaited, Lordship. But Lordship, as per Lordship, after going to the petition, Lordship, the SLC has rejected the case of the petitioner, Lordship.
State level.
State level committee, Lordship. And
What are the reasons assigned?
reasons Page number
Where is the rejection order?
31.
Page 31, my lord.
31, Lordship.
My
Right.
petition. Respondents were selected on the ground of my lord
candidates,
being senior most
name
candidate.
of which candidates recommended by the DLC, Lordship.
Page 31, my lord. Of my petition. Read petition.
31.
31,
31, my
Lordship.
lord.
Last
Roman 4, my lord. Below.
Yes.
There are 6 candidates recommended by the DLC for grade 4, Lordship. As against the
What is
vacancy,
your name, Mrs. Sinha?
Raju Gogoi, my lord.
Raju Gogoi.
Raju?
Gogoi.
It's
Yes.
31.
31, my
31.
lord. That is Roman 5, my lord.
There
And
is
serial
some
number
someone,
C, my lord.
Lordship, and
Raju Buru, yes, yes.
the following candidates are rejected by SLC due to lack of vacancy, Lordship.
Lack of vacancy position.
Yes, sir. There is a 25 Lordship vacancy against this 25 higher class of Lordship. It's only one, Lordship. But the SLC has given 2 candidates, Lordship.
Prior to that, my lord, the respondents were selected. 2 candidates were selected on the ground of my lord senior most candidate, my lord. In violation of the my lord Achut Ranjan Das case, my lord. Senior most candidate, considering the seniority, my lord. Okay. Earlier, my lord, I filed the writ petition.
Why how is there is a violation?
My lord, I have annexed to my
No, just tell us. You can just explain to us. How is Achut Ranjan Das violated? Achut Ranjan Pathak?
seniority will not be considered, my lord, while selecting the candidates for commission requirement.
It will be selected, will be done on what basis?
Not financial conditions, my lord. That is the criteria. And my lord, earlier, my lord, filed the writ petition, my lord, which was withdrawn, my lord, subsequently the present petition filed. In that petition, my lord, affidavit was filed the, my lord, Commissioner and Secretary Education Department, my lord. I have connected the affidavit, my lord, to my affidavit in reply, my lord. They have stated that 5% of 25 vacancies, 1 candidate should be selected, but they selected 2 candidates, my lord, considering the humanitarian ground, my lord, without considering the financial status of the candidates, my lord. My lord, respondent number 7, my lord, was appointed after expiry of 2 years 9 months, my lord, when the application of the respondent had spent its course, my lord.
Who is for the respondent number 7?
Yes.
You have filed your affidavit?
Yes.
What have you stated?
My lord, my father was expired, my lord, on 30/12/2010.
2000
30/12/2010.
2010.
Yes, sir. Thereafter, on 28/6/2011, my lord, I have filed application for considering matter. That, my lord, in the meantime, my lord, I have filed one writ petition matter for non-consideration. Then, my lord, this honorable court ordered to, my lord, consider my case, my lord. Then, my lord, in DLC place, my lord, and DLC, my lord, forwarded my application to SLC, my lord, and SLC selected. And, my lord, my learned friend submission that spent of for 2 years, my lord. That is not, my lord. If my lord kindly come to, my lord, page 31.
13.
31, my lord, in this
31.
Yes, my lord.
Yes, please.
Dibrugarh district, my lord. The state level committee examined the recommendation of the district level committee on 26/09/2012, 7/8/2013, and 19/3/2013. Petitioners, my lord, application was, my lord, forwarded on 7/8/2013, my lord. DLC meeting, my lord. That was reflected in page 25, my lord, with another person, my lord. My lord, my name is not there, my lord. That means, my lord, my name was sent, I think, my lord, 26/9/2012, within 1 year of my submission of application, my lord.
So the period of 2 years cannot be, the fault cannot be attributed to you if you have given it within 2 years.
Yes.
If they keep a petition
Then, my
pending,
lord,
Did you apply within 2 years?
Yes, within 1 year.
Within 1 year?
Yeah.
Then,
Hereafter, my lord, I have filed
then
one.
that objection will not come, Mrs.
Yes.
Sinha.
My lord, kindly see, my lord, page 84 of my lord, affidavit in reply, my lord, judgment, my lord, principle number 10, my lord. If the application remains pending for a period of 2 years from the date of making such application, my lord, it page 84, my lord, to my affidavit in reply, my
Yes.
lord, judgment. Below portion, my lord, below.
Yes. Number
84, 10, my lord, to my
5410 is
if the application of eligible candidate remains pending and cannot be considered due to want of vacancy for a period of 2 years from the date of making such application. All such application will require no further consideration and must be understood to have spent their. So, my lord, when the my lord state level committee selected on 1/4/2014, the respondent number 7 have already passed 2 years, 9 months. As a result, my lord, petitioner is deprived of opportunity to get appointment, my lord. And my lord,
what about the later judgments explaining this?
And my lord, if to come,
Okay,
not
we may not have time to read. We'll consider. Miss Devi, you are sitting for a long way. BJB. Which is your case? 52. Is it urgent?
Regarding taking of this, I have already taken this.
Where are you waiting? You should have asked some juniors. 52.
Yes, ma'am.
Your name is also not there. Shabnam Habiba.
No, my lord. 55, no?
55. Let us see 55. This will have another date. It's 55. Particular date.
Sorry, 55 mile. Well, as per office, I have seen yesterday and I immediately have taken steps, my lord, to respondent number 4. Principal Sapamuk. I'm sorry.
As the learned counsel for the petitioner failed to take express steps, the press upon R4 as per law, the matter is directed to. You have taken steps?
Yes.
When?
Yesterday,
Yesterday. Do office note dated 12/5/2023 reflect that step for service of notice upon the respondent of 4 has not been taken, MSMDB, BDB, learned counsel for the petitioner submit that such steps have been taken yesterday.
Yes,
With filing number?
date of filing 21/12/18. Filing number.
No, not that. On the top
Serial
left.
number of the paper.
On the top left.
Document number 3/2023. Date of receipt. Serial number is what given.
Madam, give it to us. Is that possible? No. Has been filed on 26/2023 by document number 3 of 2023. Full stop. Office to verify and proceed. Full stop. List after 4 weeks along with service report upon the respondent number 4.
Master.
Okay, rest dates will be given. Any matters were interim orders till today?